All right, if you don't have a seat, find one. Good afternoon. All right, good afternoon. We had a sign-up sheet. I think we went through two already. If you hadn't signed up already and you wanted to speak, go ahead and see one of my wonderful staff members, and we'll get you on there. I'll open this up in a word of prayer. Lord Almighty, source of light and strength, we implore your blessings here today, Lord, that we may do your will, Lord, that we may answer you with a clear heart and a clear conscience, clear soul when this life is over. In your name we pray. Amen. All right, let's talk about chicken fighting. Senator Robertson. That should be Senate Bill 102. And I will be limiting testimony today. We've got a bunch of witnesses here today, so in order for us to be efficient and hear everyone, I'm going to limit that testimony to 2 minutes. Go ahead, Senator, when you're ready.
Thank you, Mr. Chairman. My 62 years have caught up with me, so I got to find my reading glasses.
Pull one of those close to you.
Yes, sir. Thank you. Mr. Chairman, in all seriousness, I know y'all, everybody that comes in front of this committee tells you they have real simple bills that accomplish really simple things. And I certainly don't want to echo that sentiment in a nonchalant way. But what I have here is a really simple bill that accomplishes something that's very simple. In the United States of America today, during the current president's last administration, the fighting of roosters was made a violation of federal law. So they have jurisdiction over all 50 of our states. 49 of our states have their own laws that make this action illegal. And the reason they have that is because they do not want the federal government coming in and enforcing the laws within their state that their local sheriff's office, police departments, and others could enforce, the GBI and others, if there's been a violation of that particular law. It's really clear. Something else I want to be really clear about. I'm not a member of PETA, and I'm not an animal rights advocate to the point that I run around worrying about people wearing fur coats or eating chicken. I believe God put me on this earth with one task, to eat as much chicken as I possibly can while I'm here, and as much of it is fried as I can possibly get. So I promise you it has nothing to do with my unusual love and obligation to protect roosters or anything else. I spent my career in a large city of 200,000+ citizens, but I spent my childhood growing up in rural Georgia. Spent part of my childhood going to chicken fights with my grandfather, my uncle, and my father. I understand what gabs are. I understand what knives are. I understand to some degree how the gambling is done in chicken fights. I was a young kid, so of course I was never allowed to participate in that part of it. Watched my father raise grays, which were the kind of roosters he chose, raise them up and take them and fight them. He and my uncle and others were part of foul game showing groups, which were just showing off pretty birds and showing the incredible physical condition they were in. And then there was the other part of it that people rarely spoke about, which was the actual fighting and betting of these birds. This conduct nowadays is not as traditional as it once was. Today it's attached with dog fighting, it's attached with drug crimes, it's attached with sex crimes, and many other types of crimes. And to sound somewhat odd in this, chicken fighting of my days was not the crime that chicken fighting today is. It brings in a lot of other aspects of crime that I think make it much more dangerous than when 12 and 11-year-old Randy Robertson was going to chicken fights with his male family members. And with anybody that doesn't understand what gaves or knives or anything else are, I do have some products I'd like to show. And I do think we submitted a video prior to this to show some short clips of some cockfights. And with that, Mr. President, I'll stand for any questions related to LC 394595 SCS.
Thank you, Senator. I'm not ever going to be president, but I appreciate that.
Thank you. Did I refer to you as Mr. President?
You did. I don't want that job.
It must have been the prayer.
This one's already taken my hair. Questions from members of the committee, if any? Well, that's a first. So, Senator,
Yes, sir.
Chair has a question on this one. Would this criminalize just owning a fighting chicken?
No, sir, it would not.
Okay.
Because
Which?
it would not be a fighting chicken, Mr. Chairman. It would be a chicken.
Okay. What if you bought a gamecock that's had a history of fighting? Won numerous fights, won the Alabama State Championship 5 years running.
I think you'd have to have the intent of continuing to fight that chicken. I know a lot of dogs we've rescued from dog fighting operations were able to be salvaged and were able to be domesticated and moved into loving families. And I think we could do the same thing in this aspect. Those that have survived to be adopted.
Right. So tools for the crime, I'm thinking in my mind. I mean, what if I'm trying to get that little old banny rooster, that Dominica rooster, and I can't get to him because he's got these sharp spurs that I bought him with? I need to just tranquilize him. I mean, what I'm thinking of some of the older individuals that may still own these chickens, and I'm thinking, well, what if they're having a hard time getting a hold of it, don't have a tranquilizer to knock that chicken out so it can get them spurs off?
Well, Mr. Chairman, first of all, to put spurs on a banny rooster, which I had quite a few of those and have been called one from time to time. To have a spur on a banny rooster, I'd have to question the intent of the individual to begin with. But
I'm saying you buy that banny rooster, that Dominica rooster, and you've got spurs that you bought him with.
oh, he comes with
the
spurs
spurs.
attached. Okay. Well, the spurs are made to come off. Spurs are not permanent part of the chicken. I've got some. I'd be happy to show.
What if I can't get them off though?
This is a spur you're referring to,
Yeah.
and it straps over, and the rooster's common spur would go through the hole here, and it would be on here like this. You could take it off without tranquilizing the chicken if you have the skill set, which I think everybody I ever grew up with in Harris County, male and female, knew how to catch a chicken, a rooster especially. Then if you need tranquilizers, and I'm gonna be very frank with you, Mr. Chairman, and you know me, I'm being honest. I'm not trying to be cute or humorous. If you can't catch a chicken to take a spur off, you don't need to own chickens. If you need tranquilizers to catch a chicken, you don't need to own chickens. My wife and I have egg layers, and we don't have any roosters because all we want are egg layers, and we don't want the eggs fertilized. So therefore, we don't have roosters. Ours are just laying hens. But my neighbor across the street has them, and when they get over on our property, if we have to help him wrangle them up and catch them, we do.
Yeah, I just want to make sure if
Yes, sir.
there's a scenario where they couldn't catch them,
Yes,
as
sir.
long as they're not trying to use them to fight or there's not intent to fight, just because you couldn't get the spur off,
That's right.
you couldn't be prosecuted.
You're 100% right, Mr. Chairman. This is the intent, and really, I think if you reached out to most sheriff's offices and municipal police departments that may be out in rural parts of Georgia, rarely do they get calls related to this. What it is, they get a call related to drug activity, they get a call related to some other activity that when they get in there, they find out that cockfighting is a part of the overall crimes that are occurring. Rarely is it just a call just for chicken fighting. And so I think that would solve the scenario that you're concerned about. And I own a box very similar to this at home that has the spurs and everything that my family used, and it's down in the big room at my house, and it's there it's just a showpiece. And I can keep it there because I have no intent of taking those products out of there, put them on a rooster, and fighting that rooster against another rooster.
Okay, thank you.
Thank you, Mr. Chairman. I appreciate those questions.
Number 3, Representative Holly or Kendrick over there. Question.
Thank you, Mr. Chairman. I just had a brief question. Actually, thank you for bringing this. I was looking over at, I believe, it's line 60. The person who knowingly possesses, purchases, or sells. Just because I'm unfamiliar with kind of a gang cockfight, how does a arriving officer, and you've been in this capacity before, how do you know who's to blame on that? Is it just who owns the chicken? Because I would just say two chickens fighting each other. How do you know which one is which, or
Well,
who owns it?
Normally, Representative, these are ongoing investigations, but if you were just to walk up and see it, you would have to gather up the evidence. You would have to interview individuals and
Okay.
things like that. If you go to an organized event, and please understand, some of these events, they're in large buildings. They have bleachers, they have concession
wow.
stands, they have all this.
Gotcha.
And a lot of times, the individual running the operation, there are bet takers there, so there's normally documentation as to what the bets are and things like this. These are very well-run operations.
Wow.
Walking up into somebody's backyard and somebody's back there fighting chickens, I think the fact that you're on somebody's private property probably would lead you to find out fairly quickly as to who's responsible and who are the owners of the birds.
Okay. Thank you for that.
Thank you.
This bill really excites the lifelong vegetarian that I am.
All right, see no other questions. Thank you. We'll get down to witnesses. Jessica Rock with Prosecuting Attorneys of Georgia. Come on down. Senator, if you want to move over to the side. Good to see you again.
Good to see you.
Go ahead when you're ready.
Thank
Yeah,
you.
pull the microphone a little closer.
Thank you, Chairman and members of the committee. For those of you who I do not know, I believe I do know all of you, but for those who may not know who I am, my name is Jessica Rock. I am the statewide Animal Crimes Resource Prosecutor, which means I do mostly training for law enforcement and prosecutors on animal crimes across the state, have some of my own caseload statewide. But I'm also a federally sworn prosecutor, and I ended up getting federally sworn under Bobby Christine when he was the U.S. Attorney in the Southern District, specifically because of the problems that we have with cockfighting in Georgia, especially in the Southern District. And so I was federally sworn to start combating some of the cockfighting that was going on there, and I've prosecuted 3 federal cockfighting rings federally. I first want to talk about what this bill is not about, because I think there has been some fear-mongering online, some requests to contact commissioners and, talk about what this law is, and a lot of that is very false information. So to clarify what this bill is not about, it is not about prosecuting people who are simply possessing or simply breeding or simply showing gamecocks or roosters. If you look at line 64 to 65, there is actually specifically an exemption in this law that says if you have birds or possess birds for competitions, events, shows, or any other activity that is not already specifically prohibited by law, that is an exemption to this statute. It's not a bill that would cause, because as you know, this is adding cockfighting to our dog fighting law, which has been in existence since 2008. It would not be a bill that would cause a person that owns a dog leash or a collar to be arrested for dog fighting, as been previously stated. It's not a bill that would cause feed stores, lumber companies, or supply or medicine companies to go out of business, those who cater to people who, breed roosters. All of which I have seen stated by the Game Fowl Breeders Association, which is absolutely false. It is not about 2 people fighting roosters, or 2 roosters who just happen to fight. It's not about the possession of, things like these knives and gas. I possess a lot of these in my home for training purposes. We've never, since 2008, arrested somebody for, dog fighting simply because they are breeding and selling pit bulls. So none of those arguments are accurate.
Ms. Rock, we're
yes.
at that 2-minute limit. I hate to limit you. I think maybe some stuff could come out in questions from members of the committee. I've got one from Chair Lady Silcox.
Yes.
You don't? Oh, you don't have one for me?
Oh, I'm sorry, that's Representative Byrd.
It is me. Thanks very much. Thank you, Mr. Chairman, and thank you. I was actually here in 2005 when, 8, when we did the dog fighting bill. So since then, has it curbed the dog fighting at all in the state of Georgia?
I would say what it has done is raise awareness about how much this problem is, especially in Georgia. I don't think you hear it in the media a lot, but we have prosecuted quite a few dogfighting cases, both statewide and federally. So word is getting out. We also see online where dogfighters talk about our convictions in cases that we're prosecuting. So we do know that it is making a difference, yes.
It hasn't stopped.
Oh, it certainly hasn't stopped, unfortunately.
Thank you.
Seeing no other questions, thank you for being with us again. I think it's probably the third time you've been with us over the last 5 years.
Yes, it is.
All right, I want to recognize two of my district attorneys. Jason Smith, newly elected district attorney of the Tallapoosa Circuit, which I'll note used to run from about Columbus all the way up to Chattanooga. Then somebody didn't get along with a certain person in office, they split the district. And then Sarah Japor, my other district attorney for part of the new West Georgia Circuit. And then I'll give a shout out to my good friend, Mr. Bill Finch, solicitor from the great county of Forsyth. Good to have you with us, Mr. Finch. Next, have Mike Griffin. Don't tell him I can't go to church and then go to a cockfight afterwards. Just kidding, I'm funny, brother. Good to see you as always.
Thank you, Mr. Chairman. I have put a many a rooster's son in the ministry right here. But anyway, my name is Mike Griffin. I'm the Public Affairs Representative of the Georgia Baptist Mission Board. We do support Senate Bill 102. We appreciate Senator Robertson bringing this bill up. I've been testifying or supporting pretty much this kind of legislation for the last 4 years for Georgia Baptist. And we believe that there are many extenuating circumstances that are surrounding this illegal activity that is illegal from a federal standpoint. And as Senator Robertson said, it's just simply not what it was. I'm a South Georgia redneck. I nobody probably knows that. But anyway, I'm from South Georgia and in the FFA and everywhere, and we know things a little more country back some days back. And some things that are going on with the illegal gambling activity. Of course, Georgia Baptists have been against the gambling. There's even in some human trafficking issues related to this, and we do ministry and trying to help with that with Mission Georgia. And then child protection. That's one of my 3 areas with Georgia Baptist. And when you think about child endangerment and some of those issues related to minors going to these kind of events, where there's a lot of things possibly going on beyond the chicken fighting, and their access to that we think is very dangerous. And so we appreciate the Senator bringing this bill up, and we would encourage the committee's favorable support. Thank you, Mr. Chairman.
See no questions. Thank you, Brother Mike.
Thank you. Am I down for, let me go ahead and mention that for 74
I'll
again?
put you down
All
just
right,
to make sure.
Remember that for. Thank you.
All right, Mr. Mike Perkins. He's with himself, is what he said. Good to have you with us today. We always encourage individuals coming down here on their own behalf, so thank you for taking time out of your day.
Yes, sir. Thank you, Mr. Chairman. Thank you, and members of the committee, thank you for your time in considering this issue and making cockfighting illegal in the state of Georgia. My name is Mike Perkins. I'm a retired police officer and a resident of Georgia since 2018. When I started with the police department in 1989, the incidents of animal cruelty were not as forefront as they are today. Although the Georgia Animal Protection Act was passed in 2000, it wasn't until the rise of social media that propelled the awareness of animal cruelty and neglect into the spotlight. Cockfighting is not a haphazard scrap in which barnyard chickens get to arbitrarily fight with each other in the pen. Rather, it's an organized, pay-to-enter event that is commonly associated with other illegal activity, such as drugs, weapons, gambling, and acts of violence. The brutality involved in a cockfight, coupled with other illegal activities, invites a criminal element into your community, leading to its deterioration. Cockfighting is already classified as a federal crime. It is illegal in all states except Georgia, with the law prohibiting cockfighting, the local law enforcement officers are better equipped to have a vested interest with their community and protect their residents from this brutal event and the illegal activity that accompanies it. Thank you very much for your time.
I see no questions from members of the committee. Thank you for coming down.
Thank you, sir.
All right, next we have Doug Bridges, Special Agent with the United States Department of Agriculture. Good to have you with us.
Good afternoon, sir. Good afternoon, ladies and gentlemen. I work for the U.S. Department of Agriculture. I'm a special agent, and I've been fortunate enough for the last 10 years to really be able to focus on animal fighting crimes, and it's all I've worked. U.S. Department of Agriculture federally has the exclusive jurisdiction on animal fighting. So I want to highlight a couple of cases that I worked. One I worked, it was a cockfighting investigation that we did that took us about 6 months to get to this point, but we raided it on June 20th, 2020, which was Father's Day weekend. This event had 222 people that were present. It was located inside a big barn. They had stadium-style seating. They had 3 active cockpits going on. There was multiple kids that were present. When we were talking with some of the kids, some of these kids said, "This is how I have to spend time with my dad because he does this." There were people from 14 different states that had brought chickens to this event. And I know that's important right now just based on the price of eggs. The pot at the end of the day was $170,000. This event, this cockfighting barn had been in operation for 12 years. It was located in Emmanuel County. It's a big deal. That was just one case. We worked 3 back to back to back down in the Southern District. Like I said, multiple kids present. When I interviewed or proffered with the defendant's son and his wife, they thanked me. His son said, my dad, this is how my dad has to do this. He does this every day, and if I want to spend time with him, this is how I have to spend time with him. One other thing I wanted to bring up is when we were doing an investigation, we sent an undercover in. Our undercover was required to purchase a Georgia Game Fowl Breeders Association card, membership card to the GBBA before he could enter. When we did the search warrant that day, everyone there had one of those cards on their persons. You need me to stop? I know you. Was it? No, that's that. Yeah. Yes, sir. Absolutely. I'm the only federal guy that works these cases. There's one of me in the state of Georgia. The FBI and DEA they get referrals on these cases, and generally they call me. Yes, I'm 100% for the bill. So good to get some help.
159 counties you cover.
I cover the whole Southeast United States, but I live in Georgia, so it's personal to me.
I got you. One guy for the whole Southeast.
There's more. We have like one in Alabama. We have one in South Carolina. I think 3 down in Florida, but it's me for Georgia.
Okay.
So. Yes,
so the feds don't need to leave you out in their budget appropriations, what you're saying?
No, definitely not.
Okay.
Definitely
All right. Sounds good. Thanks, sir. No other questions.
Yes, sir. Thank you.
All right. Jose Ramirez. See outside. Okay. All right. Afternoon. Go ahead.
My name's Jose Ramirez. I am the president of the Georgia Gang Investigators Association. Been in law enforcement for over 25 years. Currently accepted the position with the Meriwether County School System as the first gang interventionist for the state of Georgia. Previously worked in Paulding County as a chief investigator. And I just want to touch on on this bill. Chairman, esteemed members of the committee, thank you for the opportunity to speak before you today on the issue that is deeply personal to me, one that affects not only the animals involved, but also the human psyche and the broader fabric of our society. I'm here to urge you to support legislation that strengthens laws against cockfighting in the state of Georgia. I speak from experience. Cockfighting was not a crime where I was born. It was a way of life. My dad, his father, and his grandfather, before him, all participated in this brutal activity in Puerto Rico. From an early age, I was exposed to the violence, the gambling, the criminal networking that thrives in these underground arenas. As a child, I was introduced by my dad, roosters, bred and trained for blood sport. Roosters forced into fights where the only way out was death or severe mutilation. My dad, with joy and pride, told me story after story of how the crowds would cheer, how thousands of dollars were exchanged between hands, and how the cycle of violence continued outside of the cockpit. But the damage of cockfighting extends far beyond the bloodstained rings. It affects the human soul. My dad was raised in an environment where violence was not only normalized, but celebrated. My dad became desensitized to the suffering, both animal and human.
Mr. Ramirez, I'm
Yes.
going to ask you to wrap your comments up.
Yes, sir. Sadly, my dad became involved became an abusive man that translated into domestic violence, child abuse, where I was placed in foster care. These are the effects that came from being desensitized. Violence became my dad's way of life that transitioned back into the way he brought his children up within his house and treated his spouse. I urge you, beyond the personal toll, cockfighting serves as a breeding ground for organized crime. Where there is animal fighting, there is illegal gambling, drug trafficking, weapon offenses, and overall organized criminal networking.
Thank you, Mr. Ramirez. Question from number 13, Representative Gill.
Yep. Thank you. Thank you for your service to Paulding County. We miss you already. I know it hasn't been very long. You've been Merriweather. But I just want to thank you for your testimony. I know it's personal. I can tell it's authentic, and thank you for that.
Yes, sir.
See no other questions. Thank you for your time today. Good luck in Merriweather. Been down there a few times.
Thank you.
All right. Unless my eyes deceive me, I'm going to check my other sheet. I don't see anybody else. Pat, want to comment?
Ms. Rock represents the prosecuting attorney's council.
Okay. All right. Sounds good. I can always kick all these DAs out if I need y'all's opinion. All right. So that's all we have signed up on Senate Bill 102. Senator Robertson, you can add any word you want. I mean, if you're satisfied.
Mr. Chairman, I just want to say very quickly, I appreciate the committee. I know we're late in the session. I appreciate the committee taking the time and effort to give us the opportunity to come and present this legislation. I know a lot of times these things seem little, but the collateral damage is not. And so thank you, Mr. Chairman. I greatly appreciate your time.
All right. Thank you. Number 6, Representative Panich.
I have a motion when ready.
I'll entertain it.
Motion to pass.
Motion second to pass. Any amendments? Seeing none, all those in favor of the passage of Senate Bill 102 say aye.
Aye.
All those opposed, same sign. You're on the rules. I'll get the form signed for you. Who's going to be carrying it for you?
Chairman Gullen.
Is that a problem up in our county? Okay, noted. All right, thank you. Thank you. All right. Next, I'm going to call Senate Bill 27. Senator Albers, if you want to go ahead and present. And just let us know which substitute you're working off of.
Thank you, Mr. Chairman, distinguished members of the committee. I want to begin by thanking you and your esteemed counsel, Brian, for helping to perfect this bill in the House. And we are working off of LC 443181S. All right. I'm going to jump in real quick here. Doxing has become a major issue in our state and across our nation. Several of us, myself included, were swatted back a little over a year ago. Many folks at the state level, city, county, etc. But it goes much further than those of us who are in elected office. This has become pervasive for people who are agitated with someone whom they may work with, someone they might have had a relationship with. And it's become an issue where people are sharing sensitive information. It's really a contemporary and pernicious form of harassment, just using the power of the internet. It's a gross violation of people's privacy, often resulting in emotional distress, reputational damages, and in some cases, it has resulted in physical harm and death. While we continue to digitize our lives, we have to address this issue. So this gives us a real comprehensive approach to combat doxing. It not only criminalizes the act, but it makes sure we focus on the victims and not the criminals. The legislation recognizes that the punishment needs to fit the crime, and if someone commits it the first time, it'll be a misdemeanor. If it's multiple times, it will go to a felony status. Was able to work through the subcommittee process, and again with the committee chairman and his counsel, to make, again, some perfected changes here in the House. And in the current sub that you have in front of you, it is the meaning is substantially similar to what you saw before. I was able to work very closely with our former Attorney General, Sam Owens, who assisted me as well. And you can see once we get through the definitions, as we do in all bills, it talks about the different offenses. The first person, beginning on line 48, the first offense will be a misdemeanor, and then it continues to scale up over time. You can see the fines that go along with that, as well as potential prison time. And then as you continue, it talks about what's called personally identifiable information. This is very important. You probably started to hear this terminology because it's broadly used now. PII, personally identifiable information, is when you're sharing things that are not necessarily meant for public consumption. Where somebody is currently, they're coming out of, you should go after this person. You should share things like their address or their other information that could put them in potential harm. Now, I want to make sure we understand there's absolutely no curbing any free speech. In fact, if you look toward the end of this bill, we specifically, beginning in lines 84, talked about this will in no way restrict freedom of expression, freedom of speech, the First Amendment, etc. I think this is cited in several places. I know this is a good comprehensive bill. With that, I would yield for some questions, Mr. Chairman.
Any questions from members of the committee? Number 11, Chair Lady Silcox.
Thank you, Mr. Chairman. And I was just curious, does this include AI?
Well, that's a great question because AI tends to go out and scrub all those things at one time to make it easier for someone to actually commit the offense of doxing, but it's still the individual who takes it and does something with it, or some that trains or tells AI to do something. So there's always going to be a person behind it. I look at AI as a tool in order to get something done, but this goes back to the individuals committing the offense. It's a great question, though.
Okay, thank you.
All right. Seeing no other questions, good job, Senator.
Thank you. I'll scoot over here.
All right, 27. Let's see, Lauren Collins. Come on down. Welcome.
Thank you. Good afternoon. My name is Lauren Collins. I'm an attorney. I'm just here on behalf of myself in opposition to this bill. I wrote a lot more than 2 minutes. I'm going to try to rush through this. First of all, I fully endorse and support what Mr. Fleischman said last time regarding his constitutional analysis. I'm certain he's going to have more to say here in a minute. Just to add to that, it was said a minute ago, for example, sensitive information. This bill criminalizes the dissemination of public information. It explicitly says it includes public information. To add one other area to this. Consider the sweeping jurisdiction of this. This would potentially criminalize speech by Georgians against people anywhere, wherever they might hear it. That has a massive chilling effect. Any negative online speech that I make, that any of you make about anyone, anywhere, could result in them pursuing a warrant against us here in Georgia. And I realize the thought here is about sending someone to someone's house to throw rocks, but there are all kinds of cases where I've personally been involved in that this bill reaches. For example, there are a lot of bad actors out there. And it's a legitimate interest. Investigative reporting, exposing frauds, grifters, people like that. I've personally exposed people who were faking themselves as experts, people who were trying to sell fraudulent things on eBay. You have to identify those people. You have to get at that information and make it public to expose those actors. To give a specific political example, imagine a candidate who is lying about their residency, claiming they live in a district when they don't. It wouldn't be defamation. They're a public figure. It wouldn't be defamation. You'd have a defense of truth if they oppose that. But if I expose that and it's true, they could potentially, under this law, come after me for exposing their actual residence, for exposing the truth. And that's the thing. The anti-SLAPP law, and we have a good anti-SLAPP law. I spoke in support of that when it passed. The last time I think I was here to speak on part of a bill. That helps protect Georgians against ruinous legal proceedings and the threat of civil legal action, the chilling effect it can have. Here, however, this bill creates the risk of criminal action, and there is no anti-SLAPP law to protect us against the ruinous effect of that. The standard line about defamation law is that truth is an absolute defense. It doesn't matter if someone's feelings were hurt or what their reputation was damaged.
I hate to interrupt, but just come to a conclusion.
I am. This is fine. Thank you. It doesn't matter if someone's feelings were hurt or the reputation was damaged. If what you say was true, then the law recognizes truth as a defense. This law does not recognize truth as a defense. It makes speaking truth a liability. It makes speaking the truth a crime. And so I encourage you to vote against this bill.
Thank you for taking time out of your practice to come down here. Not every attorney is sitting on the clock getting paid to come down here. So as a private practitioner, I appreciate that very much. Any questions from members of the committee? All right. I have one. Number 5. Is that Representative Neal? Yeah. Go ahead.
Just had a quick question. Did you have a recommendation for an amendment on fixing the truth aspect of it?
I think it would basically take a pretty heavy rewrite, as Mr. Fleischman will cover here in a minute. There are laws out there that cover this kind of material. I think there are existing laws on the books already in Georgia to cover true threats and the exposure of private information. But this would basically need to be a full rewrite, I think.
Number 13, Representative or Chairman Go.
Thank you. Do you see, would a newspaper potentially or the media be liable for posting some information?
As the way this bill is written, I think it is. I mean, there's a defense there at the end for if it's constitutionally protected, but if any media outlet nowadays is going to be posting it online, that covers it under this. That's potentially, for example, in the case of investigative reporting, posting potentially sensitive information online, they might have a defense against it, but that still requires you, if they want to pursue a sympathetic prosecutor, or again, use Georgia's warrant application process to drag someone into court and force them to defend themselves against possibly being thrown in jail for speaking true things about a person.
Okay. And even though it talks about, I don't know what line it is on the sub, but there was a part saying, hey, this is not unconstitutional or whatever part of that doesn't really affect the reality. Does that have any effect on the bill?
I don't think so. I mean, it might at the end of the day, if someone, again, has the resources and the time to hire a lawyer and go to court and defend themselves, they'll win at the end of the day. But that's the same kind of abuse of the law that, like the anti-SLAPP statute in Georgia, is designed to prevent in the civil arena. To prevent someone from dragging you into court and wasting your time and wasting your money. Yes, I can argue that I have a constitutional right to say those things, but that's not necessarily going to save me at a warrant application hearing. The judge might still say there's probable cause based on this. My, constitutional argument is a valid defense, but that's for later time to hash out. I still have to hire a lawyer, go to a hearing, and potentially then have to defend myself at further criminal proceedings.
Thank you.
Thank you.
All right. No other questions. Thank you again.
Thank you.
All right. So next I have Sarah Bruton Palmer, Georgia First Amendment Foundation. Welcome.
Thank you, Mr. Chairman and the committee. My name is Sarah Brewerton Palmer. I'm an attorney at a litigation firm, Kaplan Cobb. I'm also the president of the First Amendment Foundation. We submitted a letter to the committee, but in case that was a little bit 11th hour, I have printed copies that have that as well. I'd be happy to distribute those to y'all. Thank you so much.
While we're handing those out, go ahead.
I'll be brief. That letter addresses some of our concerns, and they echo the prior testimony. The crime of doxing, in particular misdemeanor doxing, is so broadly defined it sweeps in what could be a large amount of potentially legitimate speech. We certainly agree that the doxing concerns are legitimate, and there's obviously a need to address those things in the current climate. We don't think this is the right way to do it because this bill, it would be easy to accidentally commit this crime, in particular misdemeanor doxing. The reckless disregard mental state, in our view, is far too low. You have to intentionally post, but it's with reckless disregard as to the potential for a third party to, put somebody else in fear. You don't have to intend for that fear to be the result of your actions. And I think in, the current day, it's unfortunate that I think reckless disregard, you could see a lot of bad consequences from posting someone's name or their employer, with no intent. I think it's foreseeable that people could do things with that in the current climate. So reckless disregard, we think, is far too low. I would also point out that the requirement that someone was actually put in fear or harmed as a result of posting the information that's covered, the personally identifiable information, that requirement of actual harm only applies to aggravated doxing. So it's possible to commit the offense of misdemeanor doxing and have nobody ever actually have experienced fear or harm. And so in our view, misdemeanor doxing is enormously broad, and it could cause enormous chilling effects on First Amendment protected speech. I think the example of reporting on, this representative or candidate for office is lying about their residency is a great example, because that's the kind of thing that a reporter could get dragged into misdemeanor doxing as a result of this. And there are, we point out in our letter, other similar state laws that have exceptions for reporters, for legitimate news gathering, that this bill does not contain. So we have a number of concerns that we would urge the committee to consider.
Okay, thank you. And I apologize. It's Brewerton Palmer.
Yes,
I apologize for that.
No, I don't take offense to that ever.
Number 14, Chairman Croak.
Thank you, Mr. Chairman. You mentioned that same example about somebody who intentionally files to run for office and doesn't live in the district. Do you have a copy of this substitute with you?
I do, yes.
On page 4, line 79, it says, and this is under the paragraph where it says it shall not be an offense under this code section for a person to, and this is number 2 under letter D, disseminate another person's personally identifiable information for the purpose of or in connection with the reporting of conduct reasonably believed to be unlawful. So would that not be an exclusion to that example you just gave, because it's illegal to qualify to run for office in a district you don't live in?
I think it's arguable that follows in here, but I also think there's a number of other examples that you could give about reporting that would be issues of legitimate public concern, but are not unlawful conduct related to someone's employer, someone's address. The definition of personally identifiable information is broad enough that it covers an enormous range of information. So.
Okay.
All right. Number 3, Representative Holly.
Thank you, Mr. Chairman. Thank you for not only giving your testimony, but also providing us with this handout. I'm just curious, from, looking at kind of our times now, social media plays a big part in a lot of this, and trying to nail down the originator many times on the sharing of this information. I have some concerns about that with respect to like the First Amendment, because the chain of custody for, or not particularly custody, but just for that document. I wanted to know, from your knowledge after reading this, does the Georgia First Amendment Foundation see a reasonable substitute to any of the language in this bill?
Well, I think at a very minimum, our request would be that the reckless disregard standard be changed to intent. I think that it would be better to take this bill and study other ways to do this, because I think there are some in other states that have been enacted with more thought out protections to make sure that it doesn't sweep too broadly. I think that's our frontline suggestion. There is a couple of suggestions on the very end of the letter that are enumerated. One of those is the reckless disregard, and the actual, fear or mental anguish requirement as well, I think would be an important adjustment with respect to misdemeanor doxing.
Number 14, Chairman Crow.
Yeah, so the recommendation, raising the threshold for the liability to intent rather than reckless disregard, isn't that basically the difference between the doxing and aggravated doxing?
Yes,
intent?
I do believe that those would potentially collapse those two crimes into the same. I think there are a couple
That's
of
the only
other
difference I could find.
requirements. I think the actual fear only applies to the aggravated doxing, which would be starting at line 61 on page 3. For a person to be guilty of aggravated doxing, that second individual has to be placed in actual fear of stalking. So that's a material difference between the two.
Yeah, that's on line 45, though. It has the same thing for the misdemeanor. Yeah. The only difference I could find is whether it's reckless disregard or intent. And so that's,
okay.
if I was reading it correctly.
I read line 45 on page 3 to be a requirement that's what you have to have reckless disregard as to the possibility that could happen, but not to have an actual requirement that it did happen in order to be guilty of misdemeanor doxing.
Thank you. No other questions. Thank you for
Thank you.
taking the time to be here today. Mr. Flashman, did you miss the sign-up sheet?
I'm signed up at the very tippy top. It's not very legible.
All right.
But I'm here.
Oh, I got you. Okay. Well, come on down.
Thank you.
Good to see you again.
Good to see you.
If you don't follow him on Twitter, y'all, you're missing. you're missing a lot. So go ahead.
So the most important news story today in the newspapers is a story about doxing under this law. A reporter was part of a text thread about national security. And in that conversation, you learned who those people's employers were and also where they'd be likely to be. And you know what? I think there's a pretty good chance that those people will suffer mental anguish or economic harm because we know that. Let's say you charged Mr. Goldberg. What do you have to show? Well, you just have to show he disregarded the possibility that something bad could happen. Now, maybe he raises the defense, though. I thought I was reporting on something unlawful. Or, I believe it was First Amendment protected. Great. He has to go to jail first to raise that defense. And Georgia jails are not especially nice. Fulton County is not a nice jail. That is a real deterrent to truthful speech. The fact that you eventually get your day in court. In the criminal defense field, we say, you can beat the rat, but you can't beat the ride. And I don't want that happening to speech, okay? So we've heard a lot about constitutionality. I just want to talk about practically what this bill means. How is it lawful under this bill to leave a bad review of a restaurant? If I have a bad experience at the Huddle House, you could figure out from this public information where I went, maybe what the name of my server is, and it would cause some economic harm. In fact, I'm posting the bad review so you know there was a cockroach in my pancakes. Don't sue me, Huddle House. That's why I'm saying it. So I have violated the law. Now let's look at how much legitimate speech we're packing in, restaurant reviews, talking about stuff compared to what we're actually going for, which is saying something to get someone hurt. The proportions are all off. And where that does exist, I want to say this finally, we have other ways of getting at it. In Georgia, if you aid, abet, solicit, or encourage someone to commit a crime, and they do, you are liable for that crime. If I showed up to a big fight and I said, get him, and somebody punched somebody, I could be liable. I'm a party to that. That's
Mr.
very
Flashman,
common.
wrap it up as much as I enjoy hearing your analysis.
All this to say that prosecutors have other tools to get at the same conduct, and they can do it without the same problems. Thank you.
Greatest wrap it up, I think, all day. So thank you for that. Number 4, Representative Holly. Oh, I'm sorry, Representative Kendrick, who was here very early this morning
Yes,
working
I was.
away. Go ahead.
Thank you, Mr. Chair. So I'm having a hard time with all of the witnesses talking about not being, or it could possibly violate the First Amendment. So in your example about the restaurant, on line 40, it says when he or she intentionally posts personally identifiable information. So I guess I'm having a hard time connecting your hypothetical with the reviews about how that would be posting personally identifiable information. Like if they go on a Yelp, they're not posting identifiable information. The information is already there. They're just writing a review. So I'm trying to understand how that fact scenario would come under this.
Well, if you look at the language of what's personally identifiable, part of it is your employer. And all that's required is that by some combination of public information, I could figure out your employer. If you are a waitress at the Huddle House and I give a bad review, someone might figure out it was you. Thank you. Someone might figure out it was you who was my bad server. And that could violate the law and cause you economic harm or mental anguish.
But they would have to do the extra work of figuring it out.
Well, notice
you
the
wouldn't
law.
be posting it.
The law says that it has to be by itself or in combination with other information. So giving a hint can do it. And it's worth noting that so many other states have laws that are not this broad. You look at Arizona, Colorado, Kentucky, Oklahoma, Oregon, Florida, Nevada. None of the laws are this broad, and none of them require nothing more than the possibility of harm. We could copy Florida's law. I still think it would be unconstitutional because that's me, but it would be a lot closer to addressing just the bad harm. So if I were going to say, what's a suggestion? I would say, I'm going to give you a list of other state laws you could copy and paste that would be better than this one. Because you don't have to take my word for it. You can look what other legislators did and what worked for them.
Seeing no others, always a pleasure,
Thank
Mr.
you.
Flashman.
Pleasure.
All right. I do not see, unless I have missed it, anyone else here on 27, Senate Bill 27, that is. Okay, all right. What say, you want the final word, Senator? I'm sorry, but I don't mind at all.
Could I bring my my good friend General Owens up to
Come
join
on,
me for this?
come on. Always
All
good
right,
to see
thank
the
you.
Attorney General Emeritus.
The general's here.
The General is here.
Retired.
Emeritus.
Before I turn it over to our esteemed friend here, I appreciate the testimony from my friends who have a different perspective. Although some of them, as I said in the last meeting, while they weren't wrong, much of what they say is not right. I would say that last time we talked about all the civil issues it could do, and this wasn't even a civil bill. So, keeping things in context, I'd like to ask General Owens to just give a quick overview or a rebuttal.
Go ahead.
Thank you. So in contrast to the last speaker, I represent the Anti-Defamation League. What the Anti-Defamation League was look at laws throughout the throughout the country that deal with doxing and put together a model bill based on what previously is passed and what's been found constitutional. Brian proposed some changes in this sub. Brian's sub is tougher for prosecution than the original version. So when folks come up to you and say, you need to tighten the bill, that's what Brian just did, was tighten the bill. When you look at Representative Crow, what you referenced, I think line 45, it's exactly there, what was stated that she wanted. And then you mentioned it was there. Representative Kendrick, I totally agree with your position. This says on line 45, be placed in actual fear. If we want to have a requirement for intent, as one speaker talked about, you would never have a conviction. I mean, defendants can be stupid, but they're generally not that stupid. So this bill is tight, it's constitutional, and it is frankly based on a lot of hard work, to include the hard work of Senator Albers in working on this. And frankly, to the extent the bill was constitutional before, Brian's change just makes it that much tighter.
Okay.
And I'm sorry, one last comment, Chair. There's a lot of talk about the First Amendment here. Lines 84 start the fact that nothing in this bill adversely affects the First Amendment. That's an absolute defense.
Okay.
Thank you.
Yes, thank you, Mr. Attorney General Emeritus. Always a pleasure. I want to let our great attorney analyst, Brian Hines, explain the changes that we made to this to tighten the language up.
Thank you, Chair. Thank you, Chairman. Well, just in respect to the discussion about actual, obviously the intent wasn't to make it unprosecutable at all.
Right.
And that is a policy question up for the committee's, determination. I'm just going to read from Counterman v. Colorado, which is the case obviously that was used to model this off of in the first place, and what we tried to really scour to make sure that nothing else was being missed. When it said, in the case on page 6 of the opinion, the court said, whether the speaker is aware of and intends to convey the threatening aspect of the message is not part of what makes the statement a threat, as this court recently explained, citing Alanis v. United States from 2015. So the existence of a threat depends not on the mental state of the author, but on what the statement conveys to the person on the other end. When the statement is understood as a true threat, all the harms that have long made threats unprotected naturally follow. True threats subject individuals to, quote, fear of violence and to the many kinds of disruption that fear engenders. The facts of this case illustrate how.
And Brian, I apologize if I misspoke. I was simply saying that you made the bill tighter.
Totally. I'm just trying to want to make sure you also saw the case law this was based on. We tried to spend a lot of time researching this.
Agreed. I appreciate your
agreement.
time.
Number 12, is that Representative Byrd?
It is I. Thank you, Mr. Chairman. So I want to be clear, I understand this, the whole social media thing. There's a lot of ugly people out there that say ugly things about you. So if someone says something very ugly about me, Facebook, Twitter, any of that sort of stuff, I would have the ability to take them to court and have them arrested?
Not at all. No, if they would say that Representative Byrd, though, is going to be coming out of this restaurant, and you ought to go after her at 6 o'clock in downtown Woodstock, that's doxing. That's the difference.
Thank you.
All right. Must have done a pretty good job. No other questions from the committee.
Thank you, sir.
What say the committee? Number 6.
Move to motion to pass.
All right. Move to pass second. I believe there's amendment. Chairman Gullett.
Sure. Yeah, I can do that.
If you'll pull the microphone closer.
I didn't have it printed though, so I'm sorry. I came unexpected. I'm sorry. So. There we go. What I'm looking to propose is to say identify under personally identifiable information an extra caveat, and I'll get the wording right. I just want to kind of explain it first. Basically saying personally identifiable information does not include the display of a property address on a real estate or mapping platform when the address is not displayed or disclosed in connection with any information identifying the owner or occupant. Really, this is for people who have real estate sites or whatever from an address perspective, just to make sure that we're clear in the law that that's not personally identifiable information in relation to this. So it should be a friendly amendment, but I think I had it for the original, not for the sub. So where it goes, I think line 21 is the definition. And so I guess I would say on line 20, the beginning of 20, well, at the end of 24, the period, it would just be, I'll let the chair to go. This personally identifiable information does not include the display of a property address on a real estate or mapping platform when the address is not identified or disclosed in connection with any information identifying the owner or occupant.
Okay. If you'll read that one more time,
You
Chairman.
betcha. Personally identifiable information does not include the display of a property address on a real estate or mapping platform when the address is not displayed or disclosed in connection with any information identifying the owner or occupant.
Okay. And, Mr. Chairman, is this, reading through, just an example of what your language would effectuate? This would potentially make sure that car mapping software isn't accidentally included,
right.
for an example.
That is the goal, yes.
Okay. Senator
I don't think it hurts the bill. I think this is probably some folks doing a little job justification for their people they represent. But if that's what the committee will is, I'm not going to stop them from making their salaries.
Okay. Yes, ask your question, Representative Pan.
What is car mapping? Is that the word you use, car,
Car
mapping?
mapping software, I'm sorry.
I don't know what that means.
Or mapping.
Yeah.
Or mapping. Okay, thank you.
All right. You hear the amendment. Do I have a second? Second. All those in favor of the Gullett amendment say aye. All those opposed, same sign. That's on floor leader Hung. I believe you had one. Okay. Never mind. All right. Any other amendments? Seeing none, all those in favor of the passage of Senate Bill 27 with the Gullett amendment say aye. All those opposed, same sign. All right. Division. I'm going to call it. All those in favor, raise your hand.
I'm sorry, is this for I?
Yes. 2, 3, 4.
It passes. You're on the rules.
Thank you so much, Mr. Chairman. I get your signature on this form?
Yeah. Thanks for already having it
Thank you,
filled
Brian.
out. Thank you all.
Thank you, Chairman.
Thank you.
Thank you, Chairman.
Thank you, Brian. Appreciate it.
We've been going for an hour. I'm going to take a 5-minute bathroom break. We'll be back in 5 minutes. Thank you.
Hey, guess what? We got seats over here.
It's the hard part now. They get through house rules of the state.
Well, we'll get it. Just keep pushing hard, so.
That's right. Yeah, I just wanted to say thank you for the work you're doing.
Thank you for the work you do.
All right, we're back on. All right, everybody come to order. Cut it down, knock it out. We got work to do. Chairman Powell. All right, Chairman Powell, if you want to talk about the one portion of the bill that...
Yeah, I'll be very glad to, and always love coming to judiciary. Bring to you today's SB 204, and there's been a substitute, late minute substitute that's came out, and I'm not going to explain the second section that's been changed because I'm not an attorney, and I think the good chairman, my friend, will explain that. In this bill, that language in section 4 was the genesis of this bill. It dealt with district attorneys and their powers, and what we have looked at was there's a section that made this bill applicable to a Senate bill that passed, and it was Senate Bill 163 that dealt with the preemption of Second Amendment rights. Now, what I have been told, and the genesis of this part of the bill came from a section that one of the cities in this state had chose to preempt the Second Amendment law that the state had set forth. My understanding is what they've done is they have levied a fine that seems to be of an excessive amount of, I think I was told, $500 if your vehicle is broken into and somebody steals your weapon. If you don't report it, it's a $1,000 fine. Now that's a direct preemption of state law. I'm reminded the reason I was asked to handle this was that when the state did a preemption in the code section was 30 years ago. And I'm reminded that $100 fine, and that $100 fine that was levied against cities and counties that preempted the state law was set at $100. Now, what I understand, quite frankly, was that the city, when the Attorney General's office reached out to them and notified them, they said, well, it's a $100 fine, come after us. Well, the Attorney General has not apparently done that, so that was the genesis of the bill. Originally it put a $50,000 fine on cities and counties that preempt Second Amendments, and this is chosen to bring it down to $25,000. The reason I almost got into the reason I was asked to do this was there was a young man 30 years ago that did the first preemption bill. That was me. I didn't know that $100 would outpace itself and not be worth anything, and I certainly didn't think I'd be here for over 30 years since then. So I was asked to handle the bill, and that's what you will find in Section 1, and it just basically deals with raising the penalties. And if you'll look on, oops, let me get to the new version. If you look on line 87, that raises the damage to
This is LC 48 1608S. Hold on a minute. We're trying to get this handed out to everybody. Go ahead with your presentation.
Yeah, but that's what Section 1 does, is it just quite simply is that section...
All right, pipe down a little bit. Listen to the author.
Section 1, basically, it clarifies and expands the state preemption over firearm and weapon regulations, that this is a state, the state's business in the code section, and not for the local governments. If not, you'd have several hundred different rules and regs that deal with Second Amendments. And then this first section, the second section of the bill, the good chairman is going to explain that as far as the district attorney's powers.
Okay. So Senator Jones' original bill here, and just so you know what the substitute does, you're probably smart enough former prosecutor yourself. This would basically accomplish what the gentleman wanted to in his original bill upon an individual that is brought up on a new charge after they've been convicted in those enumerated charges. Reason for this: I have handed out to members of the committee a brilliant memo compiled by our Mercer Walter F. George Law School intern, and my attorney, staff attorney, Brian Hines, on the history of grand juries goes back to 1215. If that rings a bell, that's Magna Carta. 25 or so barons that stood up to King John basically became the first grand jury as a check on monarchical power, or state power, if you will. This has been with us for many years, as you'll see outlined in this. Chair thought that wanted to understand the job that our fine district attorneys have. However, the grand jury is a check on power in this country and in this state, need not be thwarted altogether at the first offense that someone may have. So, that in essence is the reasoning for that substitute. Senator Jones.
Thank you, and I'm just now looking at the substitute, Mr. Chairman, but apparently, so what will happen is, if there's a second offense or a prior conviction, the district attorney or the prosecutor may prefer by accusation, but once again, similar to my bill, that would not apply to serious violent felonies, and some of those cases would be like murder or rape. It would not apply to sexual felonies, which could be rape. Also, a case like statutory rape would also apply to that. And then the code sections which are mentioned would be such as a RICO code section that would also, so still would have to do an indictment in those particular cases. And then also, though, the other things that would have to take place is, to, as I believe as a guardrail, I believe what the chair is going for is that they've been released on bond on a commitment hearing. There has been a finding of probable cause, or there's been a waiver of a commitment hearing. So I think that this kind of does strike a balance there, Mr. Chair, of what we were trying to do originally. And
Right.
so I was think it's a good substitute here.
Okay, all right. Favorable substitute submitted to the committee. Number 7, Representative Robert.
Okay. I'm just trying to make sure, because this is just coming in front of me for the first time. Is the part of the bill that you added, Chairman Powell, Colton Moore's previous bill from over in the Senate? The preemption bill?
Senate Bill 163, and I think that was Senator Moore.
And is it identical to what it was over there?
It is identical with the exception of his bill passed with a $50,000 penalty. And it's been seen to lower it to $25,000 is something that would seem to be more applicable to a lot of folks.
Okay. There's no way in heck I'm supporting this bill.
Any other comments from members of the committee? All right. Trying to see who we have signed up for this one. Let's see. My district attorney, Jason Smith. Come on down, gentlemen, if y'all move over for testimony. And he and I are not related through the Smith family, but we are related through the Golden family distance, so it's always good to have my cousin here with us.
Thank you, Chairman. I wish I had 4 or 5 minutes to address the new amendment and my knee-jerk reactions as to it. But as to the original bill as written, I'd like to just take a very practical approach to what it would mean in our local circuit as to what it would, the immediate effect this bill would have on local law enforcement. This is hands down the most pro-law enforcement bill that I've seen in a number of years. Last Monday, we started a new term of court in Polk County. We convened a grand jury on Monday. They were there for 3 days. We presented 112 cases. 111 of those were true billed. All 112 had previously been arrested. Probable cause had been found by a judge in every one of those cases. 51 officers testified over those 3 days from 7 different law enforcement agencies. Over the weekend, once we found out the bill was set for today, I touched base with 3 different police department chiefs in Polk County, as well as our sheriff, and was able to determine determined that just for those 3 days, the grand jury, it cost Polk County just over $6,500 on top of on-duty costs to convene that grand jury. I can break those down if I have time, but that includes bailiffs, Cedartown Police Department, OT, overtime, Rockmart overtime, Rockmart extra shift had to be called in to cover Polk County overtime, the amount for grand jurors, as well as subpoena services to serve those 51 officers. Those 51 officers spent just over 100 hours of their time away from duty, away from their families if they were off duty, or away from their bed if they were nighttime officers, night shift officers. So if this bill would have been in place last Monday, Polk County would have actually saved $4,400. There would have been 70 hours saved of police time. Only 15 would have to testify of those 51. So with that stated, over the course of a year, it would save Polk County alone, just Polk County, approximately 400 hours of police time away from their families and off of duty.
District Attorney Smith, if you could just wrap up.
$26,000.
All right, thank you. Any questions from members of the committee? Thank you for coming over today. Randy McGinley from the Alcovy Circuit.
My name is Randy McGinley. I'm the DA in the Alcovy Circuit, which is Newton in Walton County. I guess I have some concerns with the substitute. I'm going to address that. This seems to essentially go backwards and make it so that we could only accuse cases if they don't have a prior offense, even for the crimes that we already can accuse. I think the way that the original bill was written is a very important thing, as other people have said, and for those reasons. But also, one of the things I want to bring up is there are a lot of crimes that are listed that we currently have to indict that involve a lot of different state agencies. And so troopers have to come from Atlanta to indict somebody for somebody's fourth driving unsuspended license, for example. Their fourth DUI. And the only reason we have to indict that is because they have 3 prior ones. And to me, that is not something that the system is designed to do or should do. I understand some of the concern about grand jury, but we've continuously eaten away about what has to be taken to the grand jury. And the idea that just because there's...
If you could wrap your comments up.
Yes, sir. And so we've already listed numerous crimes that do not have to be presented to the grand jury, and this point of this bill is to allow the most serious cases to still go to the grand jury, but the less serious cases to not have to go to the grand jury.
Thank you. Any questions from members of the committee? Seeing none, thank you. Can y'all use the other mic when y'all come up? Apparently we're having a hard time with things picking up. Okay. Jared Williams, Augusta District Attorney. One of our newer circuits. Welcome. Thanks for making the drive from Augusta GA over here. Here, there's a golf tournament coming up.
Thank you, Chairman. I hear you're invited.
Thank you for taking a moment to hear from me. I'm Jared Williams, I'm the district attorney from Augusta, Georgia, and honestly, I'm a little surprised and worried because I gave some members of law enforcement my word that I was going to come here and talk about how we can become a more efficient criminal justice system, how we can enable cases to move more swiftly through the courthouse so that we don't have people waiting in jails that are already overcrowded, so that we don't have officers who work from 7 a.m. to 7 p.m. to 7 a.m. to have to be in my grand jury lobby at 8:30 on days like today, which is grand jury day in the Augusta Circuit. And so the substitute right now would actually make more work for those officers. It would make more work for those prosecutors. It would require more people to sit in jail unnecessarily. And so I'm asking that you consider that when considering the substitute. I do want to talk about the original bill, and it's simply this. If we've got 3 guys, all right, and these 3 guys are bad guys, and they are dealing fentanyl. Now, right now, if they're dealing fentanyl, I can accuse them, all right? Now, let's say these 3 guys are convicted felons, and they have a gun in the car. I can accuse them for dealing fentanyl and having a gun in the car. The only thing I can't do is charge them with possession of a firearm during the commission of dealing fentanyl. That must go to grand jury. And that's the legal fiction or just plain old making no sense that this bill was meant to address. And it was meant to make us more efficient. It was meant to make us more effective, because deep down we know that anyone who's got a bar license knows that the grand jury is often not going to be the bastion of safety that it was meant to be. And that's not to denigrate those members of the community. It's just to point out that out of every 1,000 cases, we might have 6 no bills in the Augusta Circuit. I did the math because I knew I was going to see y'all today. And so I want to make sure I make it very clear. The original bill is going to improve community safety. It's going to help law enforcement. It is going to make the process fairer and better. And the amendment will not do that. Thank y'all. God bless you.
Might have questions. Seeing none, you're free to go. Thank you for making the ride over too. All right. Let's see. Terry Norris.
Yes, sir, Mr. Chairman.
Come on down.
Hey, just a quick note. Have not seen the sub. I did hear my DA from Augusta and his explanation of opposition to the amendment or the sub. So I'm here to support the original bill. We do think it would help us alleviate some of the scheduling issues with limited deputies all over the state. Not to belabor the point, but you all know we have a very difficult time hiring deputies in virtually every county in the state. So we were here to support the original bill. Thank the senator for bringing it forward.
Okay, thank you very
Yes,
much.
sir.
All right, let's see, Sarah Stewart. Yeah, sure.
Chairman Smith, yeah, thank you.
And Graham Younger, y'all both with Gactal.
Yes,
Okay,
yes,
thank you.
thank you. Thank you all, and I just have to very respectfully disagree with the prior speakers who came up here. I do not think that this takes away any of the powers that the district attorneys currently have, because it doesn't modify the current statute. So the way I see this new sub is where we are left is that the district attorneys can still accuse all the crimes that they currently can, with the addition of these limited crimes that are in LC 48-160-86. And I know whenever this accusation issue comes up, we like to talk about the ham sandwich. But what I would like y'all to think about is the cheeseburger, right? The ham sandwich gets indicted, but what about the cheeseburger that doesn't? That matters as well, and especially when we take that from being a cheeseburger to a person. There is a reason that we have and we talk about probable cause over and over again in our system, and that is what a grand jury hearing does. It puts a requirement of probable cause in. So we would ask, we are actually now, we can live with this smaller expansion than the original bill of the crimes that can be accused, but they're important ones. We had offered up, we would like to see in line 110C, the language been released on bond struck because we just don't see the logical relationship between someone being able to scrape together the money to post bond and get out of jail and why they should have to waive their probable cause determination, especially now if they're being accused as opposed to going before a grand jury where that probable cause determination would have been. We also would be asking that after line 16 and as a new subsection in existing 17.7.70.1, after B3, that language be added such that within 5 days of issuance, a copy of an accusation that has been filed with the court shall be mailed to the defendant and their counsel, because right now that's not happening. And I'm not finding out my clients even have been formally charged until I get a notice of arraignment, which sometimes is outside of the term of court in which they were charged. And we have a lot of important deadlines, like statutory speedy trial, that hinge on the date of accusation and not the date of arraignment. So those would be our asks.
Thank you.
On that bill.
Thank
and
you.
I don't think there are any questions, but I could answer.
Graham?
And I'll be very brief here. Graham Younger representing.
That mic doesn't work, so you're gonna have to play musical chairs.
Graham Younger representing Gactyl. The point that I think I will make is we've heard that 6 out of 1,000 figure. I'm happy that y'all took a look at the history of grand juries. That 6 of 1,000 figure is of the cases that were chosen to take to a grand jury. We believe that there is an important step in the process to make sure that you are able to find probable cause, and by taking that step away, I have no doubt that the district attorneys that we've heard here today are testifying and how this would work well in their courts. I have also heard Gactyl lawyers say, as a law school intern, they were in charge of drafting accusations. I think that taking away that process takes away the ability for a DA to say, do I have a case that I want to put in front of a room full of my own constituents? And with that, I will leave the committee here.
All right. Thank you. I see no questions. All right. That's all I believe I have on Senate Bill 204, unless anybody else want to speak. Any district attorneys that hadn't spoke? Robert, you want to say anything, speak to it? Okay. All right, sounds good. All right. I think that's all I've got signed up for this one. What say the committee? You got a question for the author? All right. All right, Chairman Powell.
Chairman Powell, thank you.
Come on down.
I'm just catching up. I'm sorry. So let me understand this bill. Actually, let me go back. Do you know what prompted this bill? What was the reason this bill came about?
The only thing that I can tell you is what passed out of the Senate almost unanimously, that there was a municipality in the state that took it on themselves, and they passed a city ordinance that said that if somebody breaks into your car, there's a $500 fine if they steal a weapon, and if you don't report it, it was another $500 fine. Now, that's the gist of what I've explained. Now, this state has always lived to the idea of a preemption clause, and then without this, and I'll go a little bit further, there was a $100 fine involved, or monetary penalty, about violating the preemption clause. My understanding was that the Attorney General reached out and explained to them that there was a preemption under state law, and that they were basically said, it makes no difference. Our fines are more than the $100 fine. Now, that's what I've been told. And the reason for raising this up, the author of the bill, what passed the Senate, was a $50,000 penalty. And it was chosen over here to drop it to something more logical. As I'd said, when this bill, the preemption was passed in the 90s, there was a $100 fine. Nobody ever thought that any of the cities would preempt a Second Amendment right, quite frankly. I think this is, regardless of what your position is on Second Amendments or weapons or whatever, I think the bigger picture of this is, do we allow cities to preempt or counties? Because then you would have several hundred possibilities of laws on the books that would affect this particular issue of our Second Amendment clause. We don't always do preemption, but in a lot of cases we do.
Okay, and so you're saying that Georgia taxpayers are going to be held liable for cities being charged $25,000 when they're trying to protect their communities?
No, ma'am, I'm not saying that Georgia taxpayers. I'm saying that only the
County taxpayers, city-
municipalities or the taxpayers in a jurisdiction that violates the preemption clause.
Right, but whether or not I agree that these types of laws should be allowed or not allowed, I may not choose whether or not my city passes these ordinances anyway. So you're ultimately passing that liability down to the taxpayers. And I just find it ironic that there's been all this talk about keeping kids safe, and we're expanding gun rights to storage now when we haven't even required our citizens to keep our kids safe with safe storage. So I will not support any expansion of gun rights or charging my municipality taxpayers money for preemption these bills. So
Well, that's certainly, you're right. This has nothing to do with children's safety or anything else. This has to do with the Second Amendment, constitutional right of the Second Amendment. And whether you believe that we should violate our own or pass on the preemption so that we have several hundred cities that are passing different rules and regulations so there's no order to things. That's the reason we have preemption, so that there's an order, so that you don't have several hundred cities or 156 counties that are passing different things that are in opposition to what the state law is.
Representative Roberts, you got to follow up. All right. Any other questions from members of the committee? Number 3, Representative Holly.
Thank you, Mr. Chairman. Thank you, Mr. Chairman Powell, for being here. So much of the testimony has not been in a vacuum, and I think you've heard for those speakers on the original bill, and I may be somewhat new to the committee. For what purpose might you find to provide this substitute to this bill after hearing the testimony from those in support of the original?
Well, I know the legislative process. This bill passed the Senate 163. It passed almost unanimous, as I have been told. And this is what we're looking at this point, to attach it to this bill. It's in the same genre that the bill was passed.
Okay.
Leader Jones, we would not leave you out of this fine discussion. Do you want to make any comments in close?
Thank you, Mr. Chair. So we have 2 sections here, obviously. So on
You
the
want to
first
speak to
section,
yours?
say again.
You want to speak to the section dealing with yours first, and then
Section dealing with mine. My concern is if it is taking away the power of the prosecutor to still charge by accusation that they can do now, and apparently there's 2 different opinions on that. I would understand if we're saying, okay, we're going to keep the powers they have now to do accusations, and then we're going to add to them if it's a second offense. I understand that. But if we're actually going backwards and saying that we're taking that power away completely from what they can draw accusations with today, that I wouldn't necessarily, I would not be in agreement with. And only reading this more thoroughly have I just gotten it. And then, of course, on the first section, we on our side voted that section down, of course, obviously. But the section I'm involved in, that is my number one concern. On the section that I was involved in, it seems like we may be going backwards, and that becomes problematic.
all right. What say the committee? Number 7, Representative Roberts. All right. I have no move from the committee.
Motion to table. Second.
All right. I got a motion to table and a second. All those in favor of tabling the bill say aye. Aye. All those opposed, same sign.
No.
All right, noes have it. The bill's still alive. Is that light flashing from earlier?
All right, no, I didn't.
Okay, I was just checking. I want to make sure.
Thank you, appreciate it.
All right.
Chairman, I move to pass.
All right, move to pass. Do I hear a second? Second. All the, number 5. Representative Neal, is this an amendment?
It's an amendment.
All right, go ahead.
Move to amend LC 481608S by removing lines 1 through 91.
Okay.
Second.
Removing lines 1 through 91. You hear the Neal amendment. All those in favor of the Neal amendment say aye.
Aye.
All those opposed, same sign.
No.
Noes have it. Amendment fails. I'll call the question. All those in favor of the passage of LC 481608S say aye.
Aye.
All those opposed, same sign.
No.
All right. I've had 5 ear surgeries, but we're going to call for a hand vote. All those in favor, raise your hand. All right. If my math's right, I believe it do pass. Thank you, Mr. Chairman, Mr. Leader. We'll sign. Senator Jones, we will get you a Rules Committee form signed here shortly, so if you want to come around back and get Chairman Powell, I believe you have one more bill that this would be Senate Bill 163. This is Senate Bill, or substitute to Senate Bill 163, LC 481600S. I understand was you were presenting that one. I tell you what, I'll do this, Mr. Chairman. We'll release you. I'll present that after we go through these others. If that sounds like a deal, you, Mr. Chairman. I'll release you and I'll present it after we finish up these others. All right, next I'm going to call Senate Bill 74. Chairman Burns, Congressman Emeritus.
Timer. Thank you, Mr. Chairman, and thanks to the committee for indulging us. We reviewed this bill last week. It is Senate Bill 74. It's the library exception removal legislation. It's straightforward. If you have the bill, we're currently working on LC 492294S. Yeah, did you change? Did you adopt the option? Let's make sure we're on the right one. Is it 492363S?
Actually, Senator, we have a...
You have a new one?
We have a substitute LC 481607.
I appreciate a copy of that. Thank you.
And if you'll indulge me real quick, I'll
Sure.
tell you exactly where we're at on that.
All right, keep going.
Okay, my understanding is, Senator, that this substitute places what you were trying to accomplish within the exception itself. You were removing the exception.
That's correct.
The way this reads is, this would be contained within that penalty or within that subsection with the exception, and it tells you when that exception would no longer apply.
So this would replace replace code section 1612-103. Is that correct?
That's correct.
Or 104.
104, yes, sir.
It would replace 1612-104. Thank you.
This basically takes what you were trying to accomplish and puts it within the exception itself and tells you when that exception no longer would apply to that librarian. And removes the affirmative defense
Removes
because
the affirmative defense.
the way it was drafted.
Is the penalty clause the same, Mr. Chairman?
Yeah, it would be a misdemeanor.
16-12-105 is not addressed in
No,
this
sir.
legislation?
No,
Okay,
sir.
thank you very much. And that would mean we would remove the affirmative defense. Would we also remove the word knowingly?
We removed that, but within the language you'll see there, it accomplishes what you were trying to do with the word knowingly.
I thank the chairman and the committee for their insightful adjustments, and I'm happy to accept your substitute.
Okay. We have a copy of the substitute available to read up front if anybody wants to grab that. Any questions from members of the committee? So instead of doing away with the exception entirely, we specify when that exception would no longer apply.
I thank you for your adjustments, and I accept the wisdom of the committee.
Okay. All right. I have quite a few. We're going to go with 2 minutes each, although if you do not want to take your full 2 minutes, I'll thank you for it. Stephen, is that Hauser? From West Georgia Regional Library System. I didn't do that on purpose, but I know you got a long drive back just like I do, so welcome. Go ahead.
Thank you, Chair, committee members. I wanted to express some concerns that we have at the West Georgia Regional Library System around SB 74. While we respect the intention of the legislation, I wanted to draw your attention to some unintended consequences of this bill that will have deeply negative effects on public, academic, and technical college library patrons. According to testimony at the committee hearing last week, the bill requires that any material deemed harmful to minors be removed from a children's or teen section to the adult section. However, I'm not aware of a children's only section at any university or technical college library. This bill would severely impact Georgia's dual enrollment students, as my colleagues at these libraries have no way of limiting these students to a non-existent children's or teen section. In discussing this bill with my colleagues at these libraries, many believe that the only compliant response to SB 74 would be to prevent anyone under 18 from entering or using their libraries. This would have a deeply negative effect on Georgia's 60,000 dual enrollment students. Librarians are not any different from the rest of our citizens in Georgia when they go home at the end of the day. But there was a good reason that the legislature carved out an exemption for libraries while library staff are at their jobs. At the time of the early 1980s, when this exemption was added to the code, obscenity laws were vague and often applied excessively, often just for a book's viewpoint that a patron didn't agree with. It had a chilling effect on libraries. States that have removed this exception in recent years, we are seeing similar results, including threats of prosecution and arrest, removal or denial of state funding, which happened in Alabama just last week, and threats against library staff and boards. State legislatures across the nation incorporated these exceptions for library staff because they understood that all of the complications mentioned above were not in the interest of the public. Public libraries are different from convenience stores and bookstores because libraries were established by Georgia Code in order to, quote, promote public education. Public libraries are required by state and federal law to prioritize the First Amendment rights of our patrons and users, including allowing community members freedom of thought and expression. We therefore differ greatly from bookstores and convenience stores, both our legislative mandate, the constitutional laws which we must adhere to, and our policies. This bill would undermine the good work the libraries have been charged to perform by the state of Georgia and our local taxpayers. We appreciate the continued support of the state in funding our public libraries and understand that the legislature has many competing interests to consider in making wise decisions for Georgia.
Thank you, Stephen. You're right on time. Thank you for coming all the way out from West Georgia. I got a question from number 6.
Thank you.
Representative Panis.
Thank you for being here. Your testimony is that effectively libraries would have to bar kids under 18 from coming in order to comply with this statute?
For the libraries that don't have children's sections, like academic libraries and universities and technical colleges.
Okay, thank you. That's huge.
Number 11, Chair Lady Silcox.
Thank you, Mr. Chairman. Isn't it true, though, that most of those academic libraries require a student ID to enter or a faculty pass?
Correct. But for dual enrollment students or students that are at college under the age of 18, they wouldn't, under this bill, be allowed to access those materials.
Okay, thank you.
See no other questions? Or wait. Okay. I see no other questions. Oh, Mr. Leader. Which number is it? 14. Okay, I got you.
Thank you, Mr. Chairman. I apologize to you and the committee for coming in late here, but the substitute I'm looking at here, LC 481607S, is just new language that would be added to the code that would provide the, I guess, the when it shall not apply. And so can the witness just explain to me how it would have this impact when we're not changing existing law in this area, we're just providing this exception, or maybe the chair can explain that?
Mr. Hauser, I don't know if you've seen the updated language.
I've glanced at it, yes, sir. I'm basing this off of the committee hearing last week, the testimony provided there. I'm not an attorney, as far as I know, but removing that exception means removing that exception. I could be, thank you, sir. Removing the exception means that it does open up academic libraries and college libraries to this, being arrested or charged with a misdemeanor. My understanding, looking at it right now, is that there are some methods of exception, but I don't see that those would apply to university or technical college. They're going to have the same books that they're going to have for their adult patrons. They're going to be in that collection. They have no way of separating that out from the children's collections.
This substitute, Mr. Hauser, just so you know, it doesn't do away with the exception as the bill did last week. It tells you when this exception would no longer apply to a librarian who distributes these harmful materials to minors.
Well, yeah, reading it now, it says, not aware of such harmful material, and had previously suggested, recommended, warned, or otherwise communicated such harmful material be considered for book challenge. And then that's, I think, number 3 says the same thing as well, correct?
Yes, fact pattern for you real quick would be new librarian in charge of a library there in West Georgia. They haven't had time to go through and check the whole catalog. Let's say it's the first day on the job, somebody's waiting in the rafters just to come down and file this challenge. Obviously they wouldn't be aware if they hadn't been able to go through the catalog. That's just a fact pattern for you.
I think that's a good point, Chair. I would point out that, say, a typical university library, there's about 300,000 books, millions of online scholarly articles. I'm not aware of any method for the staff there to go through all those materials to search what's correct and what's not.
Mr. Leader.
Well, thank you, and thank you, sir, for coming and testifying. I understand you came maybe with a previous version of the bill that you had reviewed, but the substitute that I'm reviewing here today, in my reading, is not going to have the impact that you just detailed, at least from my reading of it. And any member of the committee or a witness can maybe correct me if that's if I'm wrong, but we're not changing any existing law. We're just adding to the code what appears to be an exceptions.
So it's just kind of refining the exception?
It would allow, it specifies when the exception would not apply.
Oh, when it wouldn't apply, okay.
So take, for instance, you've reviewed that catalog and you still disseminate this harmful information to minors in that library, this exception would no longer apply to you and you could be charged with a misdemeanor.
Okay. How would that work for, say, frontline staff or my trustees, board of trustees?
Well, I mean, that's another part of this bill as far as, were they aware of it?
So I guess hypothetically, if my board was presented with a challenge
notice of it
from a patron who felt the material was harmful to minors, the board decided it wasn't, would that put them at legal risk at that point?
I would say that whoever the arresting officer and the prosecuting official would be, that they would need to be very careful of that consideration.
Okay. I do feel that would have a chilling effect on libraries, public libraries especially. I'd still be concerned about technical and academic libraries. Their processes are different. I can't speak to exactly what would work for them. But yes, I was basing my testimony off what was mentioned last week.
Okay, thank you. No other questions. Thank you for making the drive.
Appreciate it.
Let's see. Jenny, and starts with a last name. Can you pronounce that for me?
Of course. Hi, I'm Jenny LaJeunesse.
LaJeunesse.
Yes.
Okay, got it. Go ahead.
Thank you for taking comments today. I would actually like to speak to you as a parent and not necessarily as a librarian. I am the parent of an elementary age kid at Swanee Elementary in Swanee, Georgia. She reads a ton of books. That's how kids her age learn, and I'm very proud of her. I also want her to have access to the full range of materials that her public library makes available to her. I feel it's really important. I want her to learn all the things. I want to also exercise my parental rights in deciding what's best for my own child. I don't send her to the library by herself to go explore the adult section. I go with her. I know what she's checking out. I have access to everything on her library card and I can see it. I also know what she checks out from her school library, and as a parent who is an expert on my own child, I feel more qualified to do that than anyone else. And so I just want to come to you today and say that when we're in libraries, school, or when we're in legislatures and we're looking at laws concerning safety of minors, we have to put those kids first, and they're the most important. And so I'm just asking you to let us decide what our kids have access to. And that took a lot less than 2 minutes, didn't it?
It did. Thank you. See no questions. Thank you for being here today.
Thank you.
All right, we're going to move right along here. Next up, we have Patty Rebus. Reber. Okay, that's R. Gotcha. Patty Reber.
Thank you. I really appreciate you taking comments. I am a public librarian in Gwinnett County. I have been a public librarian working in public libraries since I was in 8th grade when I started volunteering in Rome, Georgia. And that was it for me. That was my first job. It's all I've ever wanted to do because I believe in the mission of the public library, which is that we are open to everyone, and not just the white public, not just the straight public, not just the cisgendered public. Everyone comes into the public library, and everyone has a right to come in and find a book where they are represented and where they can see their family represented. And so what I am concerned about is we are going to be concerned about the challenges that are made, because if a book gets challenged and then we say it's perfectly acceptable to be in the kids area, now we've opened ourselves up to prosecution, it sounds like, from what you were talking about earlier. We know what books are being challenged, and those books are LGBTQIA books. There's nothing wrong with them. They just happen to have a family that isn't a straight family in them, or a main character that's not a straight main character. And I want teens to be able to come in and find those books that they can find themselves in. Or I want the kid who comes to story time with 2 dads to be able to see a book with her family in it. So that's what I'm concerned about. And I don't want to, as a librarian, be concerned about reading the wrong book at story time, having a parent get upset, challenge it, and then being open to being prosecuted for that. So.
Number 7, Representative Roberts.
Thank you, Mr. Chair. So, you've been a librarian a long time.
Long time.
I'm still trying to understand the processes, right, and how this is going to impact different kinds of libraries, different schools. At the library that you work in, how does a book, how is it determined to be harmful? What's the process? What happens after it's been determined to be harmful? Where does it go? And then how do you police that? Since that's what you're going to be asked to do.
So we have a system in place, most public libraries do, that if a patron wants to challenge a book, there is a form that they fill out, which states, their complaints and what they have to say about it. And actually, Jenny, did she leave? She's our materials person. They all go to her. She handles all of them. But they come to us, and they are then read by a committee of people. Jenny always reads them, but then the people who review them switches, so it's not the same people every single time. So we get a wide range of experience and thought about it, and then a decision is made whether we agree that it should be moved to a different section or whether it is appropriate in the section that it belongs in. So that is how that is done.
Okay. And do you mind if I follow up? Okay. So if a book is determined not to be appropriate in the kids section and it gets moved to, is it the are there multiple
So
levels?
there's multiple levels in our
Okay.
library. There is a children's section. There is a middle grade section, which is for elementary school age children. There is a teen section, and it's a young adult section now. That's why we moved some of the books down into middle grade, and then an adult section.
Okay. So let's say it's in the teen and your board decides, or your group decides it should go into the adult section. If a parent walks up to your checkout and the child has a book from the adult section and a parent says, I'm okay with this, do you allow them to check the book out?
We have self-checkout. We don't have
self-
any control over what the people check out at all. But that would be perfectly like if a parent wants to check out a book, that would be fine. What I'm concerned about is how do you keep children from just going into the adult section?
I guess what I'm wondering is if their parent is there and they're using their library card and their parent says they can check out the adult book, are you being prosecuted because their parent made a choice that they can then check out the book? No? How do you
I don't
keep-
know.
I'm looking at the senator. He's shaking his head no. So
I'm like, I don't.
Saying that the parent has full discretion as to what materials are appropriate for their child, the way the witness testified, which we fully support. It's just the accessibility of this material should be cataloged appropriately. And if it were in a children's section, we asked it's not being banned or removed, it's being cataloged appropriately.
All right. Number 4, is this a question for the witness?
Yes, or maybe the author. So I'm trying to understand if this is a solution looking for a problem. How big of a problem is this?
It's not.
Okay.
Senator, I'll let you respond. I'll let you respond to that after we get through witnesses, if that's okay. Just mark it down and we'll respond to that. All right. Thank you for being with us.
Thank you.
All right. Miss Doris Gibbs. Miss Doris Gibbs. Going once. Going twice. Done. Miss Nora Benavides. If we could sound in the hall for Miss Nora Benavides. I don't have to repeat that one more time in case I mispronounced it. All right. Good afternoon.
Good afternoon.
Go ahead.
Good afternoon, Chair and members of the committee. Thank you all for the opportunity to speak on Senate Bill 74. My name is Doris Gibbs, and I'm here on behalf of the Georgia Library Association. I'm also a lifelong Georgian, an avid library patron, and law student at the University of Georgia. However, I speak today solely in my individual capacity, not as a representative of UGA Law, or the University System of Georgia. I urge this committee to reject Senate Bill 74 because, as written, it will harm library workers simply for doing their jobs and will restrict access to educational and literary materials for patrons of all ages. Libraries across the state already follow rigorous selection processes to ensure their collections have serious literary, artistic, political, or scientific value. Senate Bill 74 ignores these existing professional standards and the expertise of library workers who are trained to curate materials responsibly. The bill's practical implications are unrealistic. No librarian, no matter how experienced or tenured, can personally know the contents of every book in its collection. Faced with legal risk, library workers will be left with no choice but to censor their selections, leading to shrinking collections and fewer resources for the public. When library workers are targeted, libraries themselves suffer, and so do readers. Libraries provide critical opportunities for discovery, learning, and intellectual exploration. Restricting library workers will ultimately restrict access to information, disproportionately impacting those who rely on libraries the most, like rural or impoverished communities. As I conclude, I am reminded that much of my academic journey, from studying to exploring new ideas, has taken place in libraries. My firsthand experience makes one thing clear. Georgia's library workers deserve protection and not prosecution. I strongly urge this committee to reject Senate Bill 74 to ensure library workers are not subject to criminal liability and allow Georgia's libraries to remain safe spaces as for learning and growth. Thank you for your time and consideration.
See no questions. Thank you for being with us. All right. Next up, we have Dana Barrett. Or no, excuse me, that's on another one. Commissioner, I apologize. Kathy Polatsky. Did I get that right?
Yes. Well done.
I'm better with Eastern Europe sometimes. Apologies.
It's phonetic, just the way it's spelled. Prussian. Yes, yes. That didn't count for my 2 minutes, right? Okay, great. I'm Catherine Polatsky. I'm the director of Henry County Library System. I spent 10 years as a children's librarian and 13 years as the head of collection development, selecting materials for all ages. I've been the director now for 7 years. I am proud to serve the community where I grew up and where I raised my children, so I'm uniquely positioned to speak on this topic. HCLS policies provide clear criteria for the selection of age-appropriate materials and transparent processes for the community to be involved in that and to provide feedback whether they want a book added to the collection or removed from the collection. There are processes in place for that. Our policies strongly support the rights of parents to monitor what their children read and view. Those policies were adopted by the Library Board of Trustees, who are appointed in turn by the Board of Commissioners and the Board of Education. That amounts to robust local control of the library collections. Senate Bill 74 attempts to solve a problem that doesn't exist. We are already doing what needs to be done for our communities. Like most Georgia public libraries, we require that children 12 and under be accompanied by an adult caregiver at all times and within sight of that child. SB 74 actually weakens parental authority by shifting the burden of monitoring a child's reading choices from the parent to the librarian. In addition, harmful to minors is subjective. I once had a patron demand that we remove all copies of the Christian Bible from our collections due to, and I quote, graphic depictions of rape, murder, incest, genocide, and torture. That was appropriately resolved at the local level using those policies that I mentioned. But many passages from the Bible are horrifying when taken out of context, so please beware anyone quoting limited selections of any work. Further, the average age of the onset of puberty for children in the United States is 9 for boys and 8 for girls. Children need and deserve factually accurate, age-appropriate information about human anatomy. We're not talking about lurid photographs of genitalia, but drawings and diagrams that are age-appropriate and that explain the human body in an age-appropriate way. And yes, that sometimes includes humor.
Ms. Polatsky, if you'll wrap it up.
Thank you very much. I'm going to just disregard the rest of my notes because others have made very good presentations on these topics. But I want to point out that the senator said something very profound just a moment ago that is the heart of this whole issue. He said, the parent has full discretion. That is true regardless of what shelf the library book is on. Absolutely. Librarians make those decisions. We look at every book that comes into the collection for age appropriateness, for target audience, for literary quality, and we shelve it according to our best knowledge. And the parent has full discretion already. And if the parent has full discretion, we do not need to criminalize librarians.
Thank you very much. You got one question, number 3, Representative Holly.
Thank you, Mr. Chairman. Thank you, Ms. Pulaski, for coming and giving your testimony. Do I have it? I guess my question. When I read this substitute.
Is this a question that's better for the bill author?
No, it's just
for the librarian.
For the librarian. I wanted to know, Ms. Pulaski, when you read this and you think about instances where possibly harmful materials may be circulated in the range of a child, as you mentioned the Bible as an example. Would you feel? How would it, from your perspective, would you feel if perchance a member of your staff were arrested and charged of having circulated the Songs of Solomon within reach of a child, which certainly is a very graphic depiction from Solomon's account about his sexual trysts?
The staff are terrified. They're absolutely terrified. And I am fully confident that I'm going to lose some of my best staff if this passes. There's no way. I mean, I have 6 trustees. They're volunteers. So to suggest that they should review the entire catalog, that's almost 300,000 items. Actually more than that, counting our digital. There's no way to do that. The responsibility is on the parent at all times. And we recognize that and we support that. That is their right.
Okay, thank you. No other questions. Thank you for coming from Henry County. All right, I believe Nora Benavidez is with us now.
Good afternoon, everyone. Thank you so much for this hearing and this opportunity to speak. I am also going to be adding 2 minutes, which has been given to me from Michaela Arciaga. And so I think that's somewhere. I just want to make sure that's noted. Okay, wonderful. This room, it's hard to see all of you. I'm Nora Benavidez, Senior Counsel and Director of Digital Justice and Civil Rights at the nonpartisan nonprofit organization Free Press. I also serve on the board of the Georgia First Amendment Foundation, and I am our legislative co-chair. It's in this capacity that I'm here today to testify about Senate Bill 74. And I want to name a few concerns with the bill and urge you to reject the bill, including the offered amendments. I've had an opportunity to review both. Neither would cure the ailments that SB 74 offers us, and in fact, they would pose new questions and difficulties. So first, I just want to start with some foundation. SB 74 would strip library workers at all public libraries, that is county, university, kindergarten, all the way through 12, community libraries. It would strip all of those library workers of protection from criminal prosecution if they knowingly distribute material that is deemed harmful to minors. And this phrase we can talk a little bit about if we want to around what obscenity versus harmful to minors is. But ultimately there are 2 problems with this. First, many have given testimony today about the difficulty that the burden that it would place on library workers, and that librarians would be tasked with any number of reviews, checks, making sure that something subjectively doesn't match what one parent or family or another individual or a teacher might feel is harmful to a minor. And then that question of what is actually harmful to a minor. And so in the middle of that burden that would be put on library workers, there is also the First Amendment implications, and that I believe this bill would implicate the First Amendment rights of readers all over the state. There is a Supreme Court case decision in Reno versus ACLU, which found that when trying to regulate what is harmful to minors, the government cannot reduce the level of discourse to that of a sandbox, when some students are not actually minors. And so ultimately, the question is, what's going to be harmful to a 17-year-old? That's going to be a very different calculus for a library worker compared to what is harmful to a 7-year-old or another 8-year-old or a different type of 8-year-old versus another 17-year-old. And so these are incredibly difficult questions, and each of them will pose an additional burden to library workers. Other states have also tried to do this, and I do want to spend a moment just talking about what has happened in Arkansas. Arkansas passed a similar bill a couple of years ago, and initially a federal judge temporarily blocked provisions of that bill that would imprison library workers for providing harmful material to minors. And then later on, just a few months ago, in December of 2024, a federal judge ruled those provisions unconstitutional. They permanently blocked its implementation and stated, and I want to quote this, that the law was overbroad because it regulates substantially more speech than the Constitution allows, and therefore violates the First Amendment rights of Arkansas students. Its terms are so vague that they fail to provide librarians and booksellers with adequate notice of what conduct is prohibited, violating their due process rights. And so I ultimately just want to close by saying I truly believe, I've watched and I've listened throughout today's remarks, and I am so grateful for your time and your questions to others. I truly believe all of us are eager to protect students' opportunities, their liberty, and their access. Limiting student free speech is not the path to do that, and I agree that that ultimately will rest with parents and their ability. Thank you so much.
Thank you. Any questions? I don't see any questions. Thank you. And so you took Michaela
Arciaga,
correct?
yes.
Okay,
Thank
great.
you.
Next is Marlena Bergeron. Bergeron. And I see there's somebody else with the same group. Did you guys want to come up together, or James Morris?
I think we're planning on speaking individually, but we'll try to hit unique points. Does that sound good? Does that work for all of you? Okay. First of all, thank you so much, Madam Chair, for this opportunity to speak. Thank you, committee, for hearing me. Is this the one that works? Test one?
Yes,
Check.
thank you.
Check one. So, yes, I am a former Greater Clarksville Lake Regional County and Regional Library Board trustee. I'm a lifetime Friends of the Library member. I'm an educator and a volunteer and a master gardener. I'm the wife of a retired United States Air Force colonel who currently serves at the Georgia College of Dentistry at Augusta University. We moved up to Columbia County 11 years ago and have been living with there with our now 13-year-old. And let me tell you, he is a good kid and a Boy Scout, but we have much bigger problems than any books at the library. I am a God-fearing woman, but I really don't like when people are using scripture to discriminate against others in our community or try to divide us as a community. I also care about free speech, the free market, and free will. And I want to speak on SB 74 that I think creates more problems than it solves. You've heard many great points already. I also pray you will not remove exemption 1612-104 because the library, as you've heard, would have a chilling, all the libraries across the state, there would be a chilling effect. And you also heard that our deputies are already overtaxed. I would hate for our deputies to be sent into libraries. None of us want to see our librarians ensnared in our legal system, and possibly unduly, because many of us have different definitions of what we consider obscene as a household versus what is legally obscene. My time on the board since 2017, I learned that none of our libraries in the state of Georgia have the legal definition of pornography. Now, what people decide from household to household might be very different. And like you just heard, an 8-year-old might have a very different experience than an 8-year-old with 5 older brothers. So everyone has the right to govern their household. I also am concerned that our collections are not based on the library's individual opinions. We have classics, we have bestsellers and award winners, and all these books are in our library because of our tastes. So I'll just wrap up by saying that we should not hold the library accountable for what we as a community request them to have on their shelves. I also want to say that I think our libraries are community helpers. They are not criminals. We care very much about this not passing. And then to speak on the sub itself, I have some questions for you. Should I address those to you, Senator?
It's a testimony and your time is up. Thank you.
Okay, thank you so much.
Thank you.
Sections 2 and 3, I think need some more look, since we can't separate shelves and we don't know if previously suggested or warned, is the librarian warning a parent or the individual under 16 themselves.
Thank you.
If they are warned, doesn't it make it more enticing for a kid?
Thank you.
Thank you.
Sarah Hunt Blackwell. Good afternoon.
Good afternoon. My name is Sarah Hunt Blackwell. I'm the First Amendment Policy Advocate with ACLU of Georgia. Thank you all for the opportunity to come before you again. We understand and appreciate that the sponsor has spent the last week revising this bill, but even in its updated form, the ACLU of Georgia opposes SB 174. There's been a lot of great testimony that's come forth, and we also have a handout that was included in your folders with an impact story from a librarian who has been impacted by community members who did not agree with some of the material that was in a library. So I'll just briefly reiterate some points that I laid out in last week's committee hearing that still stand true today. First, SB 74 threatens the constitutional right of free speech and imposes undue criminal liability on librarians, creating a chilling effect that will inevitably force them to self-censor for fear of criminal charges. Second, SB 74 deputizes librarians as agents of government-sponsored censorship, creating a chilling effect on the availability of literature and other materials in libraries. Third, SB 74 egregiously misplaces the decision-making authority of who should allow minors access to content, an authority that should ultimately rest with parents or guardians. Taking that point a step further, SB 74 subjects librarians to liability for the mere presence of content in libraries and for allowing access to content that a minor's parent or guardian may even approve of. And lastly, it simply cannot be understated that librarians should not be responsible for making subjective determinations of what some might consider harmful or not. The obscenity test, which was outlined by the United States Supreme Court and resembled in Georgia Code as harmful to minors, is just that, a subjective test. It simply puts forth factors to consider on a case-by-case basis. It is not a definite, objective determination of what is obscene. And this is a classic example of a red herring fallacy because it points fingers at our librarians in an attempt to distract from the unconstitutional censorship occurring in our public libraries. The ACLU of Georgia fervently opposes SB 74, and we urge you to please vote no on this bill. Thank you.
Thank you. I don't see any questions. Thank you. James Morris. James Virgil Morris. Hi. Good. Yes. Thank you.
Hi there. So it seems like everybody who came up to speak before me is a lot more impressive, but I am also with Marlena from Columbia County. So what we've seen in our county is that a lot of the books being labeled as obscene and or harmful for children, the vast majority of them, as the first speaker here said, are specifically targeting people or stories about LGBT people. More so that leads into the vague definition of what is harmful for children. In fact, the section 102 that has our definition, if you can even call it that, it's extremely vague, and part C of the definition says the artwork as a whole holds some kind of security value, artistic value to people of that general age group. Though, I don't know about you guys, but I wasn't necessarily reading at the exact level of my age when I was a kid. So we have 8-year-olds who are reading at a high school level sometimes. So it's entirely within reason that those children with their parents would be in sections other than the kids section. Any book that they grab could have something that the parent labels as harmful for children, because our definition is so vague that can be anything from a same-sex relationship to abuse against animals using a racial slur. I don't think anyone is lining up to get rid of Old Yeller and Huckleberry Finn, but there are plenty of people who have a problem with Song of Achilles. So, more so, it seems like this bill is in the interest of protecting children, leaving the definition of what is harmful to children even more vague so that we're held hostage by the most sensitive readers. And that's all I got.
All right, thank you. I don't see any questions. Thank you. All right. Next is Mike Cooper. Good afternoon.
Good afternoon, lawmakers. My name is Mike Cooper. I am the president of the Friends of the Stone Mountain Sue Kellogg Library in Stone Mountain. Senate Bill 74 proposes to remove an exemption for libraries that should remain in place. This bill would criminalize library staff by holding them responsible for every word, every paragraph, and every possible interpretation of every bit of library materials. That's unreasonable. Patrons of the DeKalb County Public Library System borrowed 3.4 million items in 2024. The bill would mean that librarians could now be charged with a misdemeanor of a high and aggravated nature. To have a defense in the original bill, a librarian has to have tried to identify and restrict access to all physical or electronic material harmful to minors. Not some of it, but all of it. That is an impossible task. The latest substitute in Section 1 exempts an individual who was not aware of such harmful material. But a prosecutor may argue that a librarian should be or is aware by definition of all the materials in their library. So much for that exemption. And Section 1 is mandatory, if you notice. There is no or at the end. So to have a defense, someone has to meet the requirement of Section 1 and either Section 2 or Section 3. In Sections 2 and 3 of the substitute, library staff can only escape prosecution by aggressively and proactively urging book challenges, obscenity reviews, and the removal of materials just in case there is a complaint. That encourages the preemptive banning of material, even if the content is inoffensive. I do not believe that you should single out libraries for prosecution when virtually every adult and every child has offensive, disgusting, and pornographic material at their fingertips on their phones and computers. Do you really think that the vulgarity and sexual themes prevalent today are caused by young people going to a library and reading a book that their parent might object to? Libraries are a bastion of sanity, a place where young people can find information and differing viewpoints carefully chosen by library professionals. Please don't remove the protection librarians have had under Georgia law for more than 40 years. Librarians are not your enemy in today's culture wars. Thank you for your consideration.
Thank you. You have actually one question. Chairman Crow?
Yes,
yeah,
sir.
Actually, more of a comment. They only have to meet one of the three of those. They don't have to have or after the first.
There should be, well, okay.
So, Brian, is that correct?
There's an or.
I found it odd that there was no or between 1 and 2 when there was between 2 and 3.
Well,
And that
it's
seems
when you separate things, you only put it after the last, between the last. It's this,
Right.
or this.
All right. Okay,
Yeah.
thank you.
Thank you. Carrie Armistead? Hello.
Hi, thank you for the opportunity to speak. My name is Carrie Armistead. I'm a librarian and a member of the DeKalb County Library Board of Trustees, and I'm here to express my opposition to this bill. Librarians are trained professionals who have policies and guidelines in place to develop appropriate collections that meet the needs of their entire communities, and this legislation would undermine their ability to serve their patrons effectively. Instead of doing the job they are charged with doing, which is maintaining free and open access to information that allows people to explore different perspectives, the threat of prosecution would force them to place the opinions of one segment of the community over another when developing the collections. This bias is exactly what the library profession exists to counteract. You should be able to find something that offends you in every good library, shelved in an age-appropriate section. As you've heard, the definition of explicit or harmful is highly subjective and would lead to arbitrary enforcement of this law. There are already processes in place to challenge library materials that individuals deem inappropriate or improperly classified, but this bill takes things to an unnecessary and harmful level. It would seem that your predecessors enacted the library exception because they understood the unique mission and challenges of the librarians. So please help to protect intellectual freedom and reject this and any legislation that would criminalize librarians.
Thank you very much. See no questions. All right, let's see. John Krupski.
Sorry. I don't know what I'm doing here. Good afternoon, Mr. Chairman and members of the committee. My name is Joan Krupski. I'm a registered nurse. I'm the parent of 2 children. They're ages 6 and 8. I thought that was relevant because I know in our community a lot of the folks speaking out against the library do not necessarily have young children at this time of their lives. There was a quote that I read online in the Georgia Recorder where Senator Burns said that for reasons unknown to him, librarians were exempted from following Georgia law. So I did a little research online, and it says that these protections ensure people working in educational institutions like libraries and museums are able to provide a wide breadth of material to serve their constituents. These protections intend to curtail frivolous lawsuits against people working in places where materials of all kinds may be present. The exemptions are in place not as an admittance of inappropriate material. They are to protect the freedoms of expression allowed in these public institutions. To ensure the materials provided are true and accurate. For example, some people may not like that the library has a book about sex, sexuality, or puberty, but those books are allowed to be there and to be available to people that would read them. We already have laws that deal with obscene materials. This bill is based on a narrative about what goes on inside the library. The purpose may not be to ban books, but to destabilize and deprofessionalize the work of librarians, possibly leading the way toward defunding them. Libraries are well respected, beloved, and trusted by parents, and have not been proven to be distributing obscene materials. The explicit purpose of democratic institutions like the library is to serve the whole community, not a specific demographic. I believe that disregarding constitutional freedoms will not end in a way that is advantageous to any of us. The Constitution protects us, but only if we protect it back.
Thank you very much. See no questions.
Thank you.
All right, next have Erin Dreiling.
She had to go.
Okay.
She waited her turn first.
Let's see. Lydia starts with last name starts with a W. Willa, can you pronounce that for me?
Hi, hello.
Good afternoon.
Hi, good afternoon. Good afternoon, committee. I'm going to keep it short. My name is Lydia Willoughby. I am a librarian. I'm a constituent in District 58 here in Atlanta. I do not support this bill. I think it has a chilling effect for library workers. And I think it's also interesting to think about, like, the bill language specifies librarians, but there's a number of different people who work in libraries who have different kinds of roles. And, you know, the salary range in Georgia could range from like $15 on Sapelo Island to, you know, something much larger at a large university. So I think it also really disproportionately affects like different levels of the profession in different ways. And I think that is a problem. And I just urge you to not support SB 74.
Thank you for coming out today. No questions. Martha Scoggin. Come on down.
My name is Martha Scoggin, and I'm here.
Can you
this one? Okay. My name is Martha Scoggin. I'm from Dahlonega, Georgia, and I'm here in favor of SB 74. Now, the last time I was here a couple of weeks ago, the bill was a little different, and I understand Senator Burns has the only copy of the new bill as it's. Is this the latest version of it? Okay, what I would like to bring to the court's attention is there's a lot of publicized statements about, oh, they want to put librarians and library personnel in jail. No, that's not the objective. The objective is to restrict material that is harmful to minors from minors. And if you take a look at OCGA 16-12-102 definitions, it plainly defines what is harmful to minors. And I'm just going to read part of it. Harmful to minors means that quality of description or representation in whatever form of nudity, sexual contact, sexual excitement, or sadomasochistic abuse when it, A, taken as a whole, predominantly appeals to the prurient, shameful, or morbid interest of minors, B, is patently offensive to prevailing standards in the adult community as a whole, with respect to what is suitable for minors, and C, when taken as a whole, lacking in serious literary, artistic, political, or scientific value for minors. Knowingly means having general knowledge of, or reason to know, or belief, or ground of belief. A, the character and content of any material described in this part which is reasonably susceptible to examination by the defendant, and B, the age of the minor, provided, however...
Ms. Scoggin, I hate to cut you off where you're at your 2 minutes.
Okay, well, what I wanted to say was, if I understand correctly, this bill has made provisions that librarians or library personnel are not going to be prosecuted if they make a reasonable effort to keep harmful to minors, which is described by law, from minors. And I urgently ask you to please adopt and pass SB 74.
Okay. Representative Hall, is this a question for Ms. Scoggin and not the bill author?
It's just a question, ma'am, if it's okay. Ma'am, thank you for providing your personal testimony on this. Just curious for you, and being in libraries where oftentimes the materials are moved about, how do you see that this would affect, would this affect all librarians or just the ones that you've seen who have been able to move materials that are deemed harmful to separate stacks?
Well, most of the libraries that I have been in, it is public libraries and some school libraries, and they are able to move the books from out of one section of the library to another section. And it is not the intent of this bill, whenever you look at it, to persecute or prosecute librarians or library personnel. The whole idea is there is a website out there, sir. It's called ratedbooks.org, RATED books.org, all one word. It uses the Motion Picture Association guidelines and applies it to books. And it puts PG-13, not to be used under age 17. And I feel like that is a good source for anybody to go look and see. And the law plainly states what is harmful to minors, and it goes on, and it goes on longer than what I had time to read. But the law plainly states what is harmful to minors, and it's not subjective. Now, a parent has the choice to let their child read whatsoever they choose to let the child read. And as far as I can tell, this law will not infringe upon a parent's right to let their child investigate or read anything that they want to read.
Okay, so you're basically, would it be safe to say that maybe you would be very much okay if this law would actually relate to webmasters more so than librarians, particularly since this is about something online, right?
Well, I don't know that I would say that I think this law should particularly apply to webmasters. No, I think it applies to any literary material.
Okay.
And it's already been defined in Georgia law, what's harmful. And it goes on, and I highly recommend you read the law.
Thank you, Ms. Scoggin. Appreciate you being with us. All right. Brother Mike Griffin.
Thank you, Mr. Chairman. Again, I am Mike Griffin. I'm the Public Affairs Representative of the Georgia Baptist Mission Board. And Georgia Baptists do support this legislation. We appreciate Senator Burns, what he's doing here. In 2021, the Georgia Baptist Convention passed a resolution entitled Removing School Library Obscenity Exemption. Georgia Baptists represent up to 1.4 million Georgians, up to 3,500 churches. And we've been dealing with this issue now for about 5 years or more, dealing with some legislation, trying to make sure, as you just heard the testimony, that we dealt with those issues related to protecting our children from obscene materials. And it's just simply applying to the libraries. And Senator Burns has tried to do a good job at not throwing our librarians under the bus. It's not something to try to hurt them. It's about protecting our children and giving them proper protocols to be able to do that. One of my 3 areas of working with Georgia Baptist includes child protection policy. And last year I spoke in 6 different regional conferences dealing with child protection policy against child sex abuse. And I work with Greg Love, who is a part of Ministry Safe, dealing with sexual predators and these issues with children. And in one of my classes just in the last year or two, he gave me the data that showed that back in 2022, for the very first time, over 52% of some of the reports were dealing with sex abuse were peer-to-peer abuse. So we're now seeing this thing move to children abusing other children. And one of the reasons I believe is their early exposure to obscene material that they are not properly mature enough to be able to look at. And I've already seen in other testimonies where I've been in other hearings here dealing with other situations that children are being exposed to pornography anywhere from, 9 to 10 years of age, and a lot of times they're not looking for it, it's looking for them. But anyway, we do support this legislation and would appreciate the committee's favorable support on it.
Thank you very much. All right.
Thank you.
We have a couple more bills, so we're going to move along. Senator Burns, this is going to be hearing only. So what we will do is we will revisit this. We've got several other meetings. I appreciate the senator working with us on this to try to get it in a better position. Next, I'm going to hear Senate Bill 79, Senator Goodman. And I appreciate the family that has driven from South Georgia so far for being patient with us here today.
Yeah, that'll be fine. Mr. Chairman, you want me to get started?
Go ahead, get right in it.
Mr. Chairman, members of the committee, thank y'all for allowing me to bring this bill to you, Senate Bill 79. It's a bill, it's a Lieutenant Governor's bill. The Fentanyl Eradication and Removal Act, Senate Bill 79, working off LC 570271S. This bill continues efforts begun with the passage of Austin's Law, which y'all remember passed unanimously in both the House and the Senate last year, to address fentanyl deaths in Georgia. The bill also complements the General Assembly's ongoing efforts to combat and treat opioid abuse in Georgia, including through efforts to make naloxone widely available in schools and other public buildings. Fentanyl, I'm not going to go into that with time. Everybody here understands and knows what fentanyl is, but facts about fentanyl production and distribution. 2 milligrams of fentanyl can be lethal depending on a person's body size, tolerance, and past usage. DEA analysis has found counterfeit pills ranging from 0.02 to 5.1 milligrams, more than twice the lethal dose of fentanyl per tablet. 42% of pills tested for fentanyl contained at least 2 milligrams, which is a lethal dose. Drug trafficking organizations typically distribute fentanyl by the kilogram. 1 kilogram of fentanyl has the potential to kill 500,000 people. I wanted to share this too. I gave Mr. Chairman, I know I gave this to you earlier, but this is just an illustration if y'all wanted to, of just the small amount of fentanyl that can kill someone. Part 1 of this bill removes fentanyl from the current statutes relating to possessing, selling, distributing, manufacturing, and trafficking of opiates and creates a separate schedule of offenses specific to fentanyl and its related substances. I have a friend that's a GBI agent down in South Georgia, and he and I were discussing this. We were talking about if fentanyl, if other drugs are a BB gun, then fentanyl is a machine gun. And is what I said. And he said, no, Russ. He said, if other drugs are a BB gun, fentanyl is a nuclear bomb. And that got me to thinking about it and did a little research. And the amount of Americans that die every year from fentanyl poisoning is roughly equal to the amount of human beings that were killed in both the bombings of Nagasaki and Hiroshima. What this bill does, under current law, if the aggregate weight, including any mixture, is less than 1 gram of a solid substance, less than 1 milliliter of a liquid substance, or if the substance is placed onto a secondary medium with a combined weight of less than 1 gram by imprisonment for not less than or more than 3 years, that's for anything less than a gram. Under this bill, it goes to anything less than 250 milligrams. Keep in mind, 250 milligrams will kill 125 people. In the Senate, when we presented this bill, I had this. Y'all, this is 4 grams. Now, this is not fentanyl. This is cellulose. So I don't want to scare anybody, but this is 4 grams. This amount of fentanyl will kill 2,000 people. A Splenda packet of fentanyl can kill 500 people. That's why we're looking to treat fentanyl different in terms of the penalties. The second under possession is 250 milligrams to 4 milligrams, 1 to 10 years in prison. Currently, Like other opiates, a person must possess at least 4 grams of fentanyl to commit the offense of trafficking. This bill maintains that threshold, but establishes significantly higher mandatory minimum sentences and fines for trafficking in higher amounts. Specifically, if the quantity of the substance is more than 4 grams but less than 8 grams, the person receives a mandatory minimum sentence. Now keep in mind, mandatory minimums are already in place for trafficking. We're not adding that in there. Of 10 years in prison and a fine of $75,000. If the quantity of the substance is at least 8 grams but less than 14 grams, the person receives a mandatory minimum sentence of 15 years in prison and a fine of $150,000. If the quantity of the substance is 14 grams or more but less than 28 grams, the person receives a mandatory minimum sentence of 25 years and a fine of $250,000. And finally, if the quantity of the substance is 28 grams or more, the person receives a mandatory minimum sentence of 35 years and a fine of $750,000. And just to say this, Mr. Chairman, members of the committee, 28 grams of fentanyl will kill 14,000 people. Fentanyl is unlike anything that we've ever seen in our country before. So that's what this bill does. I called it the FEAR Act because throughout my work with Austin's Law and the good work that y'all helped me do in this committee, I have dealt with so many moms and dads and parents who've lost their children to fentanyl. And fentanyl's put fear into the hearts of parents all over this state. I'm hoping by being able to increase the penalties for those that are trafficking this stuff in our streets and in our state that we can put a little bit of fear into people that are spreading this poison in our communities. With that, Mr. Chairman, I will yield. I have with me Jack Winnie, who's the Chief Assistant DA in the Coweta Circuit, because I'm not a lawyer, I'm a farmer, and so if you want to talk about plows or tractors, but you get into the issues of the delicate issues in the grass, I've got legal counsel to help me with that.
You can see the attorney analyst, Mr. Hines, for the $5 for saying you're not an attorney. I'm going to call up Miss Beth Walters at this time. Miss Beth, thank you for being with us again. It's good to see you. I hate it's under these circumstances, but I sure do appreciate you coming up. Did you bring anybody with you?
With Rena Cobb,
Okay.
who brought me here today from
I
Valdosta.
got you. Thank you, Miss Cobb, for coming all the way up I-75, I believe that is. Come on.
First, I want to thank the chairman and the committee for having me to come back again today. It's a privilege to be here. My son was Austin Walters, and he was poisoned with a Xanax pill that killed him. On March 21st, 2025, the U.S. Attorney's Office for the Northern District of Georgia reports that DJ Simone Clemens, a drug dealer based in Rome, Georgia, was convicted of conspiring to possess fentanyl with the intent to distribute. In 3 months, she was responsible for 3,600 pills being distributed right here in Georgia. The phrase "one pill kills" implies that up to 3,600 lives may have been lost or could be in the very near future. Despite the gravity of her actions, she was sentenced to only 63 months in prison. This punishment falls short of providing justice for any single life lost, let alone the countless other potentially lives that are going to be taken by her trafficking of this deadly substance. Authorities on this case emphasized ongoing threats of fentanyl and distribution. In closing, I want to share something with you today that I pray will touch you deeply in your soul. Please listen with your heart today, maybe even an extra moment of quiet in this room, so that you can hear these words in a different and meaningful way. Fentanyl, the executor in disguise. Fentanyl does not knock, it does not ask permission, it doesn't slip in quietly and give you a chance to fight. It takes, and it takes instantly, brutally, and without mercy. It is not just a drug, it is a weapon, a chemical executor dressed up as a counterfeit escape and a cheap fix, a moment of relief. But there is no relief, only destruction. No second chances, only body bags. Fentanyl poisons and erases. It turns sons into statistics, daughters into overdose reports, families into war zones of grief. It is a chemical warfare against our children, A grain of it smaller than a piece of sand is enough to shut down a human body like turning off a light switch. One touch, one life, and it's gone. It's a murderer without a face. It doesn't care that they had dreams, that they were more than their worst decision, that they were trying to get better. It doesn't care if they have family waiting for them at home. It doesn't care about the love that is left behind or the hollowed out parents or the siblings who will never be the same. It's a liar. It sells the promise of a high, but it delivers a coffin. It takes them and they'll feel good for that shutdown of a moment, but in their lungs, it's over. It's done. It's a death sentence. And yet it floods our streets. Pills laced with it are handed out like candy. Dealers scum with no soul selling it, knowing damn well it's going to kill. Governments allow it to slip through our borders like water through open fingers. And politicians stand at podiums talking in circles while parents are digging graves. Fentanyl is not an accident. It is not an unfortunate side effect. It is a mass poisoning, a silent slaughter. And every time another child dies, it tightens its grip, it spreads further, takes more. We are at war. And the enemy isn't just the powder itself. It's the apathy. The people who look the other way, the ones who shrug and call it an overdose, as if our child chose this, as if they weren't tricked. And until the world wakes up, and until the people scream louder than the silence that fentanyl leaves behind, and until we stop treating it like a bad habit and start treating it like a calculated extermination that it is, it will keep taking and taking and taking. I'm asking you to fight for your children, your grandchildren. Put fear in place of this killer on our streets and in our neighborhoods. Please help us to pass the Fear Act. Thank y'all so much.
Thank you, Ms. Watson. Thank you for your patience through today. It's good to see you again.
It's good to see you.
Thank you, Austin.
Thank you.
So, thank you. All right. Next, I'm going to have Mr. Jeff Breedlove.
Thank you, Mr. Chairman. Please, the committee. I'm Jeff Breedlove. I'm a person in long-term recovery from addiction. Unlike Austin, I'm blessed to be a survivor. And I have the great privilege to be here today on behalf of the Georgia Council for Recovery. The Georgia Council for Recovery endorsed and continues to support Senate Bill 79. We appreciate the good efforts of the senator from the 8th and want to thank him for participating, by the way, at the panel stop in Valdosta on the Fentanyl in Georgia conversation series, which we held across the state. I also want to thank Beth and her husband Gus for also participating on that panel, and more importantly, for the grace that both Beth and Gus have shown Georgia as they endure this unimaginable tragedy. It's my privilege also, and my responsibility before this committee, to acknowledge that this policy issue is of great concern to many in our Georgia recovery community, and it's a very emotional issue to so many of my brothers and sisters in recovery, and we do respect and honor their points of view. While no legislation is perfect, and we do believe that there are still serious policy efforts and funding efforts which must occur here in the Georgia General Assembly, I want to publicly express our gratitude and posture of the state Senate, especially the senator from the 42nd, who has worked to move forward on both legislation and a study committee to incorporate companion legislation which incorporates peer-led recovery programs for Georgians who, while in active addiction, are in custody of Georgia in any aspect of the criminal justice system. In conclusion, Mr. Chairman, we must work together for a bipartisan Georgia solution to this medical issue which is killing more Georgians 18 to 45. And if you remember nothing else, recovery is real. Thank you, Mr. Chairman.
Thank you. All right. Next, I have Graham. Oh, sorry. We've got a question.
Oh, yes, sir.
Is this about the bill, or is this a better question for the author?
It's a question. Either one could answer it.
Okay. Ask your question.
Okay. I understand. Are some of the concerns that your members have about criminalizing the possession of fentanyl by adding more time to the maximum?
That sounds like a question for one of the prosecutors. We'll hold that question.
Okay.
Yes.
All right. Thank you, Mr.
Yes, sir, Mr.
Breedlove.
Chairman.
Always good to see you, and thank
Yes,
you for
sir.
your work
Yes, sir.
on behalf of those trying to recover. All right. Next, I have, let's see, Sarah Stewart.
Chairman, is it okay if Mr. Younger?
Thank you.
We can.
We can get there, I think. Thank you. My name is Graham Younger. Thank you, Mr. Chairman. Representing the Georgia Association of Criminal Defense Lawyers. We want to thank Chairman Goodman for bringing this bill. I think that I know through the experiences of GACTL lawyers that I've talked to that fentanyl is a huge danger. We appreciate the testimony that we've heard there. The one thing that I want to point out to folks is that having spoken to a lot of GACTL lawyers in particular, a lot of our clients essentially have been unintentional users, not able to distinguish between fentanyl and any other sort of drug, and something spiked with fentanyl. In that case, we might ask for some change in the maximum sentence here, as we're thinking about those users based on the fact that they may not have any idea what we're talking about. And again, exactly the same punishment I think that we see here for the traffickers themselves.
Yeah, just to build a little bit on what Graham is saying, the only ask that we would have here is to maintain the current sentencing structure for possession of fentanyl. And part of that is based on the experiences even that we've heard today. Oftentimes the substance that the person is caught with is not, they never intended to have fentanyl, right? They thought that they were getting another substance. For instance, cocaine right now has a maximum sentence, pure straight possession of 1 to 3 or 1 to 8, which is what the current sentence max is for fentanyl as well. And we would ask that that just be left the same, because it feels like we're punishing people extra who largely do not have the intent to possess the substance for which they're being punished, because they thought they were buying cocaine and it's laced. Turns out to be fentanyl. That ecstasy pill you thought was X is fentanyl, and now you're subject to a higher max. And really, we think that we achieve the goals through the changes that are made in the manufacturing and structuring portions of the bill.
See no questions. Thank you all very much. Okay, let's see. Who else do we have? Mr. Winnie, do you want to speak real quick?
I was just with Senator Chairman Goodman, just in case. I don't think he needed me.
Yeah. Let's see. Okay, I got a couple more, so just hang tight. Brittany Gallivan, how do you say your name? I'm sorry. I like it.
It's Galvanoskis.
Galvanoskis.
Yes.
Okay, now where does that name originate from?
Lithuania.
Lithuania. Okay, we got a lot of Eastern European influence here today. Good to see you. Thank you for coming.
Thank you for having me. My name is Brittany Galvanoskis. I'm the Executive Director of Living Proof Recovery in Rome. I'm a mother, a returned citizen, and I've been in recovery from opioid use disorder for over 7 years now. This bill may sound tough on crime, but a majority of those that will be punished as a result will be people that are using or misusing substances. It would send people living with substance use disorder to prison for years for an amount that I used to buy on a regular basis. People do not recover in prison. I didn't. I was still using while incarcerated, and many are doing so today. I also didn't stop after my overdose in 2017. What finally helped me recover was access to peer-led recovery services and other supports, not punishment. The last time my daughter's father, Bo Eller, was in recovery, he said to me, "I'd rather die than go back to prison." He experienced a fatal overdose in 2021. This law would not have saved him, just as those that were in effect at that time did not save him. The fear of returning to incarceration and the shame he carried as a result of returning to use pushed him further away. This ultimately led to his death and to my daughter and her sisters losing their father. People are dying inside Georgia prisons. Overdose deaths and homicides are increasing. We're locking people into places that are traumatizing and unsafe and expecting them to get better. It doesn't work. It was our state leaders, including the General Assembly, that helped create and or oversee the Georgia Opioid Abatement Trust. That trust was designed to invest into harm reduction, prevention, recovery, treatment, public awareness campaigns. Recovery champions, including you all, built a system to save lives. This will do the opposite. We cannot, on one hand, fund healing and on the other, vote for policies that reintroduce punishment and trauma. Let's be honest, these punishments haven't worked so far. They don't reduce crime, they don't reduce use, they don't reduce deaths, or we wouldn't have people dying, over 100,000 people dying in our country annually to overdose and substance use related deaths. We know what works, and it's what the abatement trust was set up to do.
Thank you for your testimony here today, and thank you for sharing your story with the committee. See no questions. Thank you.
All right.
Okay, I have Mr. Evans, Jesse Evans from the Cobb County District Attorney's Office. Good to see you again. It's been about a year.
I'm here to testify in support of this bill for 3 reasons. I've been a prosecutor since 2001. I've also served as police chief for 2 years. The 3 reasons are: it removes a legislative ambiguity, it corrects an ambiguity created by case law, and finally it corrects a sentencing anomaly that currently exists under the law. First, if you go to the drug trafficking statute, most of the substances that are intended to be covered by the trafficking statute are mentioned by name. Fentanyl and fentanyl analog don't appear anywhere in the drug trafficking statute. When a DE agent calls me and says, is drug trafficking in fentanyl illegal in the state of Georgia, unless you know to follow the statutory paper trail, it's an ambiguity that can be easily corrected by putting the words fentanyl and fentanyl analog in there. So that's the statutory ambiguity that can be corrected. There's a case that came out called Roundtree, which is an anomaly case. A 3-judge panel incorrectly found that the sentencing scheme does not include mandatory minimums, and that's not the intention of the legislature. They found that you could probate defer, suspend part of the sentence, and Roundtree has been widely considered an anomaly. This bill will correct that case law ambiguity as well, to make it clear that no, the intention is, the default is that we have a mandatory minimum for trafficking in fentanyl and trafficking in other drugs. That being said, it brings to the third point, which is a great point. There are 3 mechanisms to allow for downward departure within the trafficking statute already. It involves the prosecution, defense agreeing, and the court approving under some circumstances with findings. That's great. Anytime we have discretion for the criminal justice system to say, in the interest of justice, we believe it's okay to reduce a crime, I find that to be a positive thing as a prosecutor. Here's the sentencing anomaly. If a person receives the mandatory minimum of 10 years to serve, you're going to serve about a third of that. All right, 3 1/3 years. If you downward depart to say 5 years because you believe it's in the interest of justice, the current statutory scheme says you have to serve that without parole. So you're better off getting convicted of the 10-year sentence than availing yourself of the interest of justice downward departure, because inexplicably the lesser sentence would be without the possibility of parole.
Thank you, Mr. Evans. See no questions. Thank you again for taking time out of your day to be with us. All right, I think that is all I have for 79. My good friend from South Georgia. Oh, yes, I missed one.
I sent an email. I just missed the sign up. Could I testify?
Sure, come on down. I'll give you 2 minutes. Sorry about that.
Thank you, guys. I know it's been a long day. Oh, excuse me. I'm sure everybody's ready to get home. My name's Jeremy Sharp. I've got a long ride ahead of me as well, headed to Dahlonega. I'm here to urge you to table and amend Senate Bill 79, a bill that, while well-intentioned, treats personal addiction and drug trafficking as the same action. Let's be clear. The bill mandates prison sentences of up to 10 years for as little as 250 milligrams of fentanyl. That's the equivalent of 10 pills, a quantity easily held by someone struggling with severe substance use disorder. Under this bill, the person would be charged as a major trafficker. We're not distinguishing between users and sellers. We're treating a person in relapse the same as a criminal kingpin. This bill eliminates the possibility for treatment diversion. If someone leaves rehab, relapses, and gets pulled over in crisis, they go to prison for a mandatory of 5 years. Their family is powerless, the judge's hands are tied, and the opportunity for healing is lost. This is not just a flawed policy, it's a perverse injustice. Georgia's own data shows our prison system operates at over 100% capacity. More than 40% of correctional officer positions are vacant. Inmate suicides and homicides have risen by 150% in the last decade. Over 60% of formerly incarcerated individuals will wind up back in prison within 3 years. We spend $1.3 billion annually on a system that fails addiction. It fails to rehabilitate people, and it fails to keep us safe. If incarceration worked as a deterrent, we would not be in the worst overdose crisis in American history. Instead, we must distinguish between possession and distribution. We must expand naloxone and testing strips. We must reform prisons to offer real rehabilitation, including vocational training, mental health care, and drug treatment. I ask that you guys invest in mental health and medicated assisted treatment. So if we send someone to jail for addiction, is the problem solved? No. Very often it's exacerbated, compounded, and made worse. So I ask the distinguished members of this committee to take a second look, to look at amending this bill and make a clear distinction between a drug user, someone like myself, and a drug kingpin. Thank you very much for your time.
Thank you very much. All right, now, yes, sir.
I just want to say this bill does, in terms of possession, this bill does not mandate any sentence. If it's possession, it can be a probated sentence. They can get a year of probation. The judge does not have to send anybody to jail for possession. I want to just make sure that everybody's aware of that. The mandatory minimum that's in this law concerning trafficking, the mandatory minimum is already in the penalties for trafficking under current law now. This bill does not mandate anybody who is in simple possession to go to prison. It has no mandatory minimums, anything. So I just want to correct that for the record.
Thank you.
And can I add one more thing, Mr. Chairman?
Sure.
I remember when we had Austin's law, there are some folks that don't think and I'm not saying any of the speakers or anyone in this room believes this, but there's some folks that don't think anybody needs to go to prison when it comes to dealing with drugs. I remember when we had Austin's law, and I had a mother by the name of Stephanie send me an email and Facebook message, and her son Ryan died from buying drugs that were laced with fentanyl. The same dealer that sold Ryan those drugs had killed 3 other young people after Ryan had died. So, when we talk about heartbreak, look at what this person's, doing in the community here in Georgia.
All right, thank you. Motion do pass. Second. Although, number 6, Representative
amendment?
Panish. All right, what is it?
To strike section 1-2. I believe it's a friendly amendment.
I know Mr. Winnie well, so if you want to refer to his legal counsel on
I can
this.
speak to this.
Yeah, that's fine. I'm just
well,
saying.
this is a lieutenant governor's bill, and I had been speaking with my dear friend who's also co-chair of the Georgia Israeli Caucus, and the lieutenant governor's office is fine with this amendment, so long as we keep in other words, the possession statute that's currently in law will stay in law. But the trafficking language in this bill stays as it is.
All right. Got that? Let's see what the House Judiciary Non-Civil Full Committee thinks about it now. All right, you've heard the Panish amendment.
Second.
Or repeat it one more time.
It's to strike section 1-2, which essentially would strike lines 15 through 33.
I think we've got a question from number 13, Chairman Geller.
Yep. So you said Lieutenant Governor is okay striking this as long as the remainder of the bill pretty much stays intact. Does he want this strike, or is this something you want stricken, or is it something a friendly amendment, or is it not a friendly amendment? I guess we're trying to get.
That's a good question. I will say,
I heard it as friendly.
You heard it's friendly?
It's
yes,
friendly.
If you're asking me if it's a friendly amendment, then yes, it is. I mean, we've been working back and two with the Lieutenant Governor's General Counsel.
Okay.
And so, I think that as a district attorney, I think Mr. Winnie, I think you're.
The heart of this bill is.
Mr. Winnie, if you pull the microphone closer.
I can speak for myself. I think the heart of this bill is the remainder of it,
Okay.
The trafficking component of it.
Okay. Thank you.
All right. And I trust Mr. Winnie. He's a pretty hard-nosed prosecutor, but he's fair. So I appreciate that.
Mr. Chairman.
All right, I got a motion second. A motion and a second for the Panitch Amendment. All those in favor of the Panitch Amendment say aye.
Aye.
All those opposed, same sign. Ayes have it. All right. Seeing no other amendments, I'll call the question. All those in favor of the passage with the Panitch Amendment say aye. Aye. All those opposed, same sign. Congratulations, you're on the rules. If you'll get me a form, if I don't have one already.
Mr. Chairman,
Who's carrying this?
Whip Burchett.
Okay, gotcha. Thank you.
Hey, Mr. Chairman, good to see you.
Thank you. Likewise, Mr. Winnie. All right. Okay, next. He's still a senator, but the next treasurer of the United States of America, Senator Brandon Beach. What's your bill number again?
It's SB 244. It's a new LC. Y'all did a committee sub, and I'm going to let Chairman Dempsey talk to the bill. It's LC 550628S. LC 550628S. I will talk about part one, and then I'll hand it over to the chairman. Isn't that what it is? Which one?
We have the LC 47361.
New one's in there.
New one should be in y'all's photos. We'll suspend for just a second.
There it is.
Yeah.
Isn't that it?
It is.
Is this it?
Yeah.
It's LC 550628S. That's the one we're considering. Do you need that? You need one,
Mother may I?
Chairman Leverett has returned to the world of civil.
Got it. Glad to have back with you, Mr. Chairman.
Okay, make sure you use that microphone over to your left.
Okay. All right. Thank you, Mr. Chairman. Committee members, thanks for having me. The original bill was SB 244, and I'm going to speak to that. That's part one, which is on page 2. And basically all this does is if a prosecuting attorney in a felony or misdemeanor case is disqualified for personal or prosecutorial misconduct. So if a DA is disqualified for misconduct, and then the overall case is dismissed by the courts. So it takes two things to happen. You gotta have the district attorney disqualified, and the court has to dismiss the case. Then those individuals that were indicted would be able to go to the court and ask for reimbursement of attorney fees and reasonable cost. And that's all this bill, all this part of the bill does. Part one. The fees would be paid for by the county in which the case was brought, and again, in conclusion, this is will not happen very much because you have to have the prosecuting attorney must be disqualified, and then the courts must dismiss the case, and then those that were indicted could then seek financial relief. You know, when you think about somebody getting indicted, it's somewhat of a scarlet letter. It is tough. It can ruin your life, and it can definitely cost you a lot in attorney fees to defend yourself. And so I just am doing this so that people that have been wrongly accused and then the case goes away, they have some type of ability to recoup some of their fees and reasonable cost. And then I'm going to turn it over to Chairman Dempsey. She's got the rest of the bill, and I think she said y'all have already passed this bill once.
We have. Thank you. Thank y'all for being patient. Y'all are the hardest working committee here, no doubt about it. So the Wrongful Compensation Act that we passed out of committee, passed on the House floor this year, is basically still intact right in here. There are very minor changes to improve it, and I will go over them for you right now. So it still provides the claimant prove the same elements to the same burden of proof and provides the same compensation amounts. The procedural amendments include addition of a definition section to ensure that terminology used in the bill is clear and not subject to interpretation. assurance that the Attorney General and prosecuting attorney has notice of the claim with opportunity to respond. Provision of an appeal right from the administrative law judge's ruling for the claimant and the Attorney General and the prosecuting attorney. It also includes the requirement that a claimant waive further claims against the state for wrongful conviction, and provides payment of successful claims through a trust fund appropriated by the General Assembly rather than through the judiciary budget request, which is how it was when y'all voted on it before. So we've improved that process. The amendments will ensure that the state's interests are protected while creating a fair and expeditious process for innocent exonerees to receive compensation.
Thank you both. Any questions from committee? Lighting up. Okay, I think Chairman Silcox. Go ahead.
Thank you. I was just curious from Representative Holcomb if these were necessary. I think these sound like good improvements on the bill in terms of defining these terms and what Chairman Dempsey was saying.
That one? Okay, thank you. Yes, thank you for the question. I am supportive. I think the changes in essence are pretty small and I would describe as even marginal, but the core components are that it has it go through an administrative law judge and it sets a specific set of money as opposed to a range, which was in earlier versions. And with respect to this part of the bill, I'm definitely very supportive and glad that it's still being considered.
Okay, great. Thank you.
Number 10, floor level.
Thank you. This is a question for Chairman Beach on your section. Yes. Just to make sure that I know your intent. I'm assuming that you believe with line 28, so improper 28 and 29, improper conduct on the part of such prosecuting attorney, you would be referring to the case of the specific defendant where the prosecuting attorney was improper?
Right.
Correct.
And it's
so
misconduct, whether it's prosecutorial misconduct or personal misconduct, they are disqualified.
Correct.
And when that happens, then the case...
That specific defendant can go ahead and ask for attorney fees. And then if I can have one more question, it's line 42 and 43. So as far as, it's my understanding that each county has they allot certain funds to their prosecutors. And so I would assume that the county would get the funds from the money that they allot to the prosecutors in their county. Is that your intent?
That would be up to the county chairman and county commission, but they do fund the sheriff's department, they fund the district attorney's office, and so on. So if, let's say, there were $2 million in attorney fees that were given back to some defendants that asked for it, then they could ding her budget or his budget or her budget $2 million if they deemed necessary. But it would come out of the county funds.
And you're leaving it up to the county to decide where that...
Yeah, that's their decision, how they decide to do what they do.
Gotcha. Thank you.
All right, number 16, is that Chairman Leverett?
I believe it is, Mr. Chairman. This is for the future treasurer on section 1.1.
Yes.
So as I read A, it provides an independent means for recovering costs and attorney's fees if there is improper conduct and it does not require dismissal of charges. Is that right?
No, it does. Now, tell me that question again.
Well, so my understanding was your understanding of the bill was that the only way a defendant could get fees in connection with a motion to disqualify is if the charges were actually dismissed.
Correct.
Against the particular defendant. And I think that's what B says.
Yeah,
B talks about the that the case has to be dismissed. It says criminal case being dismissed against defendant.
But I think my question is, it seemed to me that Section A is an independent basis to get fees without requiring dismissal.
No, it has to have the dismissal of the case.
I guess my somewhat ignorant question would be, where is that requirement in A, or is it somehow engrafted in there and I'm not seeing it?
Floor leader home.
Yeah. And I don't know if that changed, but in Chairman Beach, I think your intent was that there is improper conduct and the case gets dismissed.
Correct.
But I do think that Section A is a standalone, like Chairman Leverett said, where with improper conduct, a defendant would be entitled to attorney fees. And then also in B is a separate where improper conduct and a dismissal would be also
Well,
a
the
reason
intent
for
is to
attorney
make it
fees.
difficult, to be honest with you. I mean, the intent is that it's got to be disqualification and dismissal.
And dismissal.
Maybe I'm not reading it that way, but I can see how you could, Mr. Chairman.
I mean, it would just seem to me we need to combine A and B into one paragraph to achieve the author's intended result, if I'm reading it correctly. Thank you, Mr. Chairman.
All right. I see no other questions from members of the committee at this time. Thank you for y'all's good work. If y'all want to sit over to the side. Let's see, Garland Favorito. Good to see you again, sir.
Thank you. Thank you, Mr. Chairman. I'm not sure if these are on. My name is Garland Favorito. I'm the co-founder of Voters Organized for Trusted Election Results in Georgia. We like to believe that we've led the election integrity movement in Georgia for 20 years. So I just wanted to make two quick points in less than about 2 minutes. First, and we would agree with Chairman Leverett's interpretation that it's an either-or situation, but that is what it should be. This is basically good legislation that simply provides that a defendant is entitled to attorney's fees and court costs in the case of where a DA is disqualified for prosecutorial misconduct. It shouldn't necessarily require whether or not the case is dismissed. If there's prosecutorial misconduct, the defendants should be entitled to at least the attempt to be able to recoup some of their costs. So this is good legislation, and as the bill is drafted right now, it protects citizens. We believe that is the duty of the legislatures, to protect the citizens, not to protect any county government or state government. And I think this is why the bill passed as is, 55-0. The last point I wanted to just make is for historical perspectives, just so you know, as a resident of Fulton County. Our DA on September 15, 2021 went to the Fulton County Commission requesting an extra $5 million annually to reduce the murder case backlog in Fulton County. That is something that we all would like to see done. However, in January of the following year, when she got the money, she opened an investigation that eventually indicted 18 of her political adversaries. That was not the appropriate use of our taxpayer money, being from Fulton County. So we are not necessarily concerned about whether or not Fulton County might be done, but in conclusion, many millions of dollars have been spent on this of our taxpayer money. So this bill will protect us as it is written right now. We urge you do pass.
All right, I see no more questions, Mr. Garland, so it's all right that you stood up too quick. No, I'm just messing. All right, let's see, Commissioner Dana Barrett. Fulton County Commissioner, District 3. Now tell me where District 3 covers here in Fulton County.
Good afternoon, I guess good evening, and thank you. Yes, District 3 in Fulton County is sort of right smack in the middle, Buckhead, down into Midtown, and a little bit up into Sandy Springs.
Gotcha.
So right in the
Okay.
middle.
Thank you.
Yes. A couple things about 244. First of all, the substitute that was provided that I think y'all had before we just passed out the new ones, which was LC 47361-8S, actually had sections A and B combined and addressed that issue of whether or not it should be only in the case of a disqualification. So that substitute, I wasn't even going to speak to that part because I thought that would be included until I saw the one we are talking about, LC 550628S. So I was really only going to talk about the section that talks about who pays, which in this case is supposed to be the county. But if it stays in the way it's written now in this substitute, it does read to me as well that it would be only in the case of misconduct, whether the case goes on even to a conviction. If there's misconduct by the prosecutor, this would, as A reads, mean that someone is entitled to get their legal fees back, even if the merits of the case were good and the case continued on and they were convicted. And that does not seem appropriate to me. But I really want to focus my short time on whether or not the county should pay, because there's a significant flaw in that logic. The district attorneys do not represent the county when they bring a criminal case. They represent the state. They are state constitutional officers. When you see a criminal case, it does not say Fulton County versus the criminal defendant. It says the state of Georgia versus the criminal defendant. Fulton County is not a party to the legal action at all in the case that we're talking about, and nor is any other county in any other criminal case. So if there is a remedy to be paid, and that's a discussion that you all can have politically and decide what you will, but if there is a remedy to be paid to a defendant, it should come from the state coffers. Interestingly, I believe the second section of the bill, which I have not really read but was just glancing through, doesn't say where various payments should come from, because that's not, it should be coming from the state. That's, if you were sued, it would be the state. So, you know, when the district attorney is sued, legal action is brought, it is the attorney general's office that defends her, and any payment comes from the state. So I would recommend either just striking that sentence altogether that says where the money should come from, or changing it to say coming from the state. And as I said earlier, I think the way A and B were combined in the earlier sub was more fair and more thorough.
Okay. Thank you very much. I see no.
May I add just one other thing? I want to point out that I'm speaking for myself as a commissioner, not for the board. However, at our previous board meeting, we did have a majority of the board that agreed that these funds should be coming from the state.
Okay. Sounds good. Thank you. No questions. All right. Is there anyone else signed up to speak for or against this bill? Got a lot of other district attorneys that this will affect if y'all want to testify to it.
I'll be very brief, Chairman.
Yeah, come on down.
And just from your home county and your home tax base you pay into, there were some numbers of $2 million kind of thrown around here or there. My county budget for the district attorney's office in Haralson County is $183,000 total to run the entire office for the year. That's it. We have zero paid state, zero paid county district attorneys. All of our assistant DAs are in fact state paid. So, for instance, a $2 million shot to Haralson County would in essence bankrupt the county. That's just my 2 cents as to it, or $20,000 fee or settlement would in essence hit our office well over 10%.
And just to clarify, a county or municipality cannot bankrupt in the state of Georgia. We just wouldn't have the money to pay it.
We wouldn't have the money to fight off landfills.
That's a good point. Thank you for that. All right. I don't think anybody else has signed up to it. All right. Gonna hold. We don't have a quorum at this time, so we're gonna come back to this, Mr. Senator Treasurer. So, and that's appointed, that's not confirmed, is it?
It's just appointed, so I will be starting after session. I spoke to the president yesterday and told him I wanted to finish session.
So this could be the last bit of scrutiny that you ever have to go through with elected officials.
How many people do y'all have to have?
Well, hang on just a second. We'll come back to you. All right, next up we have Senate Bill 268, Senator Robertson.
That's why they left.
Go ahead and when ready, Senator.
Thank you.
Mr. Chairman, will you have another meeting in the next? Thank you.
Thank you, Mr. Chairman. This is a bill that was...
The microphone, Senator.
Thank you, Mr. Chairman. This is a bill that was heard by the Judiciary Non-Civil Subcommittee on relating to individuals interfering with first responders doing their job. I'm reading off LC 560346. And the primary heart of the bill starts on line 18, where it says a person commits the offense of interference with a first responder when he or she, after receiving a verbal warning not to approach from a person he or she knows or reasonably should know is a first responder, and who is engaged in lawful performance of legal duty, knowingly and willfully violates such warning and approaches or remains within 25 feet of the first responder with the intent to impede or interfere with the first responder's ability to perform such duty, threaten the first responder with physical harm, or harass the first responder. And up on line 15, we do have a definition of harass. And then it's they would be guilty of a misdemeanor of higher aggravating nature. Primarily, it protects those responding to crashes, fire service. A lot of our fire departments in the state, municipal and volunteer fire departments, they bring paramedics out on the equipment, but they don't necessarily have an ambulance. So this protects them until an ambulance gets there and they get the individual loaded up and transported to a medical facility.
And this was the companion bill to the HALO Act?
Yes, sir, it was.
Okay, all right.
And really, I think the biggest difference is, if I recall, is the distance in the HALO Act. I think was a distance, and mine was based on the 21-foot reactionary distance that most public safety and law enforcement agencies are trained with for response.
Would you be opposed to us going with the same language that we had in the HALO Act that came out of the House?
What's the distance, if I could ask? That would be my only concern. I think the distance was very close in the HALO Act.
There's no distance requirement. If they're obstructing or hindering a public safety official from doing their job, they could be charged with obstructing.
Right. The only reason we put the 25 foot in there is the reactionary distance is 21. Added the 4 feet is because I wanted to make sure I was not infringing on anyone's First Amendment right to yell, "Are they okay?" and all this other kind of stuff, or they could even film it. They just could not interfere or harass the first responder. But as always, Mr. Chair, I'm at the will of the committee.
Okay.
I'd be willing to entertain any conversation related to language.
All right. Any questions from members of the committee? Okay. Thank you. If you want to just take a seat over to the side
Yes, sir.
there. Let's see. Robert Cornicelli?
Yes.
Did I get that right?
Surprise.
Bam! Where does your name originate from?
Yeah, I have to say I am from New York, but I live in South Carolina, so please don't hold that
Which
against
part
me.
of South Carolina?
Somerville.
Somerville.
I want to
Dallas.
raise my children with the Southern culture.
That's a good one. The Green Wave over there. Go ahead.
So I want to thank you for having me. My introduction is probably going to be longer than my comments. My name is Robert Cornicelli. I'm a Navy veteran. I'm a retired Army officer. I was the executive officer to the director of operations in DIA, so we did intelligence, and I also was involved in conflict resolution, where I came up with a concept of a buffer zone. I'm also the founder of Veteran Recovery Coalition and the president of Veterans for America First. And my comments are these. Recent years of heightened social unrest in major cities have highlighted significant challenges faced by law enforcement officers and first responders during the discharge of their official duties. Research shows that close proximity reduces reaction time, increases risk for officers and responders when managing potential risks. A minimum distance is critical to create safer environments, minimizing unnecessary confrontation and enhancing public safety. The establishment of a 21-foot buffer zone, and as a matter of fact, the HALO Act and 268 both have 25 feet. Where was I? Zone has been the instances of deliberate obstruction or aggression towards law enforcement and first responders undermine their critical role in safeguarding public safety. These actions disrupt operations and contribute to broader societal instability. Recognizing the need for boundaries that protect those serving in these roles is essential to ensure that their ability to perform their duties safely and efficiently while upholding the safety and welfare of the community. So basically, this is all about, I was in conflict resolution, but that means a conflict has already taken place. We want to create a buffer zone so confrontation doesn't take place, and it gives that as Senator Robinson said, there's a 21-foot reactionary gap that they're taught, law enforcement officers are taught in school. And that means that it takes someone about 1.5 seconds to get at a law enforcement officer or a first responder within that 21 feet. If you're carrying an M4 or you're carrying a sidearm, you can't pull that weapon out in 1.5 seconds and protect whoever it is you're protecting, yourself and that weapon. And as we know, there are weapons in this building. So if you allow people within 1 foot of all your officers who are carrying a weapon, how do they protect that? So creating this buffer zone gives law enforcement, first responders, the ability to de-escalate. So I'm 100% in support of it.
Thank you. Thank you. Appreciate that. Thank you for driving all the way from Somerville. We used to jokingly refer to it as Scummerville.
Yeah. Not anymore. We're here. Thank you.
Good Baptist college over there, too. All right. Kurtik. Kartik Butt. Okay, thank you very much. Come on down.
Thank you so much.
Yes, sir. Thank you.
So this is just for safety for my other officers, because I used to work in the Cobb County Department of Public Safety, and I have a lot of friends from police and the sheriff department across country. So this is my goal is simple: they come from work and they go home safe. To just keep their privacy for public safety, peace, and security.
Fair enough. Thank you. No questions. All right. Let's see. I think that's all that I have. Gactal or Pack? All right. Sounds good. Well, that's all we have. We don't have quorum on that. May see you tomorrow.
I appreciate y'all giving us the time. And
Well, may see you tomorrow. How about that? I'll talk with you.
I got a full committee schedule, but you know I'll run over here.
You got a good vice chairman? You got a good vice chairman?
I'm not a chairman, sir. I'm
They demoted you?
no. If you're in a leadership position over there, they won't let me be a chair. That would be what they consider too much of Randy Robertson. So they
Understood. Understood. All right. All right. Sounds good. We'll see you tomorrow sometime. I'll let you know.
Thank you, sir.
We'll try to accommodate as much as we can. I have one I'm going to present to the committee, and then we can adjourn for the day. You have before you substitute the Senate Bill 163, LC 48 1600S. What we have, and I'll present real quick. This is 163, Senate Bill 163. This is a committee sub. Does everybody have it?
Yes.
Okay, all right. I present this to the committee here. This is dealing with, we have a system in the state of Georgia where if your local law enforcement agency decides not to bring charges or arrest someone, you can go to the magistrate court judge and take out a warrant application and have a hearing. Basically, this is trying to curtail that system being abused and making sure that if these individuals are trying to maliciously prosecute somebody, just don't like them or ill feelings, obviously no probable cause to arrest with a law enforcement agency. This would also cover to make sure that this system is not abused. I know few of us on the committee have had to deal with cases like this before, usually defending those. And you've got a pro se individual on the other side. It can get a little complicated, but basically this bill looks to prevent those abuses, especially with subpoenaing witnesses. That subpoena power, whether issued by the attorney on defense or a pro se litigant, or if they're represented by counsel, this is trying to prevent that abuse from occurring, basically wasting witnesses' time in addition to the court's time. That's what you have before you. And we can take a few questions or hold those for tomorrow. I know it's almost dinner time or past. All right, seeing none, y'all chew on this overnight and we'll visit again tomorrow. We're adjourned.